the state and federal agency section. We will have a presentation from Caltrans from Sri Balasubramanian. He's Deputy Division Chief and he is online. So let's pull him up if we can. Thank you.
Hello, Amanda, can you see me?
We can hear you.
Okay. And here, awesome, that's great.
We can't. Okay.
Awesome. Good morning, everyone. My name is Sri Balasubramanian, and I'm the Deputy Division Chief for Traffic Operations for Caltrans, or the California Department of Transportation. As you just heard earlier about the MMBI, we have not only MMBI, but other utilities that use our right-of-way to allow them to put their lines and their services. One of the things that we do is, before we get into the details, I want to thank CPUC and BIA for this invite, and I apologize for not being able to be there in person. Caltrans recognizes the importance of collaborating and having open, clear communication and consulting with tribal leaders and other representatives on the on transportation issues, especially when it involves a tribal land. So we hold that relationship quite dearly. In fact, Caltrans has a deputy director for equity and tribal affairs who directly reports to our director and chief deputy to enable smooth communications and collaboration. We also have Native American liaison branch under this deputy that is located across the state. We have different Native American liaisons and Native American coordinators. For those who don't know, Caltrans has 12 districts. The state has divided into 12 districts, and each of those districts have a Native American liaison. And we also have a Native American Advisory Committee, or what we call as the NAAC, which was established in 1996 to improve the government-to-government relationship between Caltrans and the California Native American tribes. Again, it consists of representatives from tribes across the state. The committee meets once every quarter. I think the next meeting is scheduled sometime in November. Whether it's utilities coming in or our own projects, we coordinate very closely with the tribal governments in the local area. So with that, let's go to the next slide, please. So primarily, as you all know, Caltrans is involved in the transportation infrastructure. That's our main bread and butter. Next slide, please. For all the transportation projects, and you have heard earlier in the conversation today, we follow the Department of Interior's regulation and as described in 25 CFR 169 for the lands that come under tribal lands that come under BIA control. It's a grant of right-of-way for transportation projects. For tribal lands that are not governed under BIA, the negotiations occur directly between Caltrans and the tribe in that area when we build those projects. Next slide, please. Then the next thing, which I think is kind of the focus of this workshop, is utility infrastructure. Next slide, please. When it comes to utility infrastructure, Caltrans and BIA recognizes that this is not the same thing as transportation project. They are a separate use case, and therefore all the utility companies are required to obtain their own rights through their application process. They have to follow the process that is established, and they get that the permission or the rights to go through the tribal lands, even though that part of the land is where the state highway system is situated. They still have to go as a separate process. It does not give us the same. It doesn't have the same ability as, say, for example, a transportation project. And that's where next slide, please. That's where the encroachment permits come into play. Encroachment, whenever anybody gets into our right-of-way, the Caltrans highway right-of-way that Caltrans controls for the state highway system, they'll have to come and get an encroachment permit from us. Next slide, please. So they need to be obtained for any, as I said, any encroachments and all encroachments within the state highway right-of-way. There are federal and state regulations and laws that govern that, whether it is utilities, special events. Sometimes you'll see parades, marathons, local celebrations that happen on the state highway system. Those have to be done under an encroachment permit. If you're putting a driveway that connects to the state highway system, or vegetation management, those all have get done under an encroachment permit, which Caltrans issues to the permit applicant. Sometimes there is collection of seeds within our property. Again, that is done under an encroachment permit, but that one is called a consent letter because usually it happens in a couple of days. But nevertheless, whenever anybody enters into the state highway right-of-way, they have to get an encroachment permit. Now, these encroachment permits are revocable. It's not permanent, it's not long-term, it's a temporary encroachment, and you get the permit for a certain duration of time. Now, there are instances where if it's for a longer term, then our right-of-way division gets involved and you have licenses and leases. But in general, when somebody comes into a right-of-way, does some work and leaves, it's done under an encroachment permit. These permits do not provide any property rights. They just allow you to come in and work on that right-of-way and leave. And these permits are not transferable. So whoever applies for the permit is the permittee. And if somebody else needs to do the work, or if one entity transfers that work, or let's say there is a utility company there now, and they are selling their utility to somebody else, and the new utility comes on board, then that new utility will have to come and get an encroachment permit. Next slide, please. And the reason we do that, because when somebody comes in, you have live traffic, you have high-speed traffic. We want to make sure the encroachment permit is required or is obtained to make sure there are no impacts to the operations of the highway. More importantly, it's for traffic safety and the worker safety. And when we say worker safety, whoever comes and works within the highway right-of-way, we want to make sure they're safe. They work in a safe environment. So that's why for traffic safety and worker safety, they have to come to an encroachment permit. We look to make sure they're all in compliance with the federal and state laws and regulations. And not only that, we also make sure that all these utility companies and others get all the necessary approvals from various regulatory agencies and the tribal governments. So, for example, if you're in the coastal area, you have the Coastal Commission that has to take a look at the scope of the project and make sure they're in compliance. If it's on tribal lands, we need to make sure that the tribal government there takes a look at it and make sure that the work that is being performed is in compliance, and they're comfortable with what the work is happening. And then once we have those kind of documentation and it is submitted to us, that's when we issue a permit. This includes the consent from the landowner or land easement owner within the state highway right-of-way. This is where we do have a lot of consultation between the encroachment permits office with the tribal government in that area to make sure there is consultation. There's constant communication between the tribal liaison that we have at Caltrans and the local tribal entities to make sure that everybody is comfortable with it. Our environmental group also is very closely works with our Native American liaison on all the projects, especially ground disturbing projects, to make sure that there is open communication and collaboration before we issue an encroachment permit. So those are key or some activities that Caltrans is involved in as far as whenever a work gets done within the state highway right-of-way. That also happens to be part of the tribal lands. Next slide, please. There are two, like I said, two groups. For the longer term, we have the Division of Right-of-Way and Land Surveys, and for these shorter duration engagements or coming in and doing some work, even if it is part of a larger work, there is the encroachment permit. So the right-of-way is governed by the right-of-way division, and Renee Fletcher is our current division chief, and you have her number up there. And then if it is an encroachment permit or you have any questions regarding encroachment permits, please do not hesitate to be please do not hesitate to reach out to me. You have my number there. You can definitely reach out to us and get any of your questions answered. So with that, I will stop. And I see a comment in the chat. It says tribal governments need to be aware that they are exempt from encroachment permit fees. That is correct. Any public entity that tries to do or wants to do work and applies for an encroachment permit, they are considered as a local public agency. So for public projects that the tribal governments are building within the highway right of way, they are exempt from the encroachment permit fee. So again, I want to thank CPUC, the BIA, for giving Caltrans and me the opportunity to share some of our thoughts when it comes to encroachment permits. But if there are any questions, please do not hesitate to reach out to me. Thank you.
Thank you so much for that great presentation. And now we will move on to our last panel session and presentation session before lunch. It is our tribal presentation session. And I would like to invite Pilar Thomas from Quarles and Brady to provide her presentation.
Good morning. Now's the time to have eyes on the back of my head. I don't know what I'm going to say. Good morning, everybody. It's really nice here. Is it supposed to be raining soon? Does this work? Okay. Oh, what happened? Oh, you couldn't hear me before? A little bit? All right. Do I have a clicker or somebody going through the... Just next slide. Okay, very good. Well, first of all, thank you for having me. My name is Pilar Thomas. I'm a partner in the law firm of Quarles and Brady. I'm based out of Tucson, Arizona, member of the Pascua Yaqui tribe. I practice primarily in the area of tribal energy and economic development. Let me start with our standard disclaimer that the views and opinions that I'm about to express are my own. They do not represent the views or the opinions of our tribal clients or firm. So with that, I'm going to kind of kick off this panel with just a high-level overview, some of which you've already heard, but talking about it from the tribal side of things around right-of-ways and right-of-way requirements. So setting some context, and I know a lot of the discussion today is around broadband, but I also would like you to keep in mind there's a lot of clean energy work that has to be done, that will still continue to be done, and much of it can't get done unless we solve some of these right-of-way issues that we have. So with that, I'm just going to really cover off a couple of major areas. One, a kind of a background on the federal laws. I'll just very high level, because we already heard from in a lot of detail the BIA person talking about their right-of-way process. But again, just digging into some of that from the tribal perspective. And some other key legal considerations that I know a lot of tribes see, not just with respect to expired right-of-ways, but kind of the intersection, as we heard from Caltrans, for example, and the CDT people around how we match up right-of-way needs for electricity and broadband and roads and pipelines, given the energy context that a lot of us are dealing with. So in addition to kind of the background and some legal considerations, I want to just kind of keep in mind other issues that we see in right-of-way, resolving right-of-way issues, whether new right-of-ways or expired right-of-ways, the NEPA process itself, and the fact that we have to go through it for every single right-of-way because the federal government has to approve every single right-of-way. We don't have yet a Hearth Act for right-of-ways. We're working on it. We're trying to get some federal legislation to do that. And so until we get the authority for tribes to approve their own easements, which we do not have, until we get that authority under federal legislation, we always have to go to the feds and we always have to do NEPA. Huge issue for lots of us. Sorry, BIA. Some other things to think about in this right-of-way context is transmission planning. The new big buzzword around the West especially, and I know there's a lot of new transmission lines that are getting planned. There was one line that I'm familiar with that was going to run just right to the north of here, right? From El Centro over to your now dead San Onofre nuclear power plant, and a power line that was going to be built by Merchant Transmission, and a real interest in working with the tribes along the way. So to the extent that transmission planning is also something we know is coming, and we know we will need right-of-ways to do it, I think I would add that as we're thinking about the right-of-way issue, we can't be caught flat-footed when somebody shows up saying, I want to build a 200-mile transmission line, and you've got to deal with not only the regular right-of-ways, but the tribal right-of-ways as well. And then lastly, decarbonization efforts. And I know this isn't necessarily something you guys are talking about, but we are decarbonizing, right? We're pulling out natural gas pipelines as we speak. Some utilities have been ordered to pull out natural gas pipelines. So what does that mean when natural gas pipelines are crisscrossing Indian country in existing right-of-ways, and they are now being pulled out as the decarbonization effort comes, and new right-of-ways are needed for new power lines to replace the power, the energy that the natural gas was providing. So, and then I'm not going to mention crazy hydrogen, but we've got other new energy infrastructure coming. And so I would just want to kind of put all that out there for us to think about as we're thinking about the right-of-way issues that we are currently dealing with. So next slide. The three major laws we're dealing with here, well, two major laws and a set of regulations. The Non-Intercourse Act, which I'll talk about in just a minute, the Right-of-Way Acts, and then the BIA has already talked in detail about the right-of-way regulations. So next slide. Why is it that it's the United States who's the only one who can issue right-of-ways? It goes back to 1790. For those of you who aren't familiar with Indian law, the second law that Congress passed after the Constitution created the United States was the Trade and Intercourse Act of 1790. That regulated trade and intercourse with Indian tribes. No one could do anything with Indian tribes unless it was pursuant to the Trade and Intercourse Act. One of the key provisions in that law remains law today is what we affectionately call the Non-Intercourse Act, which says that you cannot purchase, grant, lease, or convey lands or any title or claim thereto an interest in lands from any Indian tribe or Indian nation without federal consent by treaty or federal convention. So that is why the BIA is still in our business, because the Non-Intercourse Act from 1790 is still the underlying law of transferring interest and rights in Indian lands from tribes to anybody else. 1976, a reaffirmation here in the Ninth Circuit that if you don't have federal approval, you don't have a valid right. So if you're trying to use Indian land and the tribe is giving you the easement and the BIA has not approved that easement, it's not a valid easement. Ab initio, from the beginning. So it's very important that we understand who has the authority to do what with respect to right-of-ways. And you cannot have an adverse possession of Indian land. You cannot have an implied license or an implied easement. There is no such thing as an easement by necessity for all the real estate lawyers out there. You can only have an easement, a valid easement, if it's expressly written easement approved by the BIA. There's no backing into it, so to speak. Okay, next slide. So with that, we actually have several right-of-way laws on the books with respect to tribal lands from the late 1800s, early 1900s, and I think Michelle's going to go into this in a little bit more detail. We have what we call the original right-of-way laws, which were right-of-way laws adopted for specific purposes. So there's a right-of-way law for pipelines. There's a right-of-way law for telegraph lines, which have been included for telecommunications. There's a right-of-way law for roads. There's a right-of-way law for railroads. Those are actually all still active laws. They are still in effect. The BIA does not use them anymore because in 1948, Congress passed the General Right-of-Way Act, and that was for all purposes. And in part because we started to have electricity, we started to have other uses or purposes for right-of-ways that they did not envision in the late 1800s, early 1900s. We also had a key change in the law pre-1934, before tribes were reorganized in the Indian Reorganization Act. The secretary could just approve rights-of-ways without any consent from the tribe or other landowners. So the 1948 Act acknowledged finally tribal jurisdiction, tribal governance, and the tribal right to consent to any right-of-ways on Indian lands. Some utilities still have pre-1948 right-of-ways. They were 50-year right-of-ways that just kind of kept getting renewed. I've actually seen some pre-1948 right-of-ways. There's been some case law about what do you do with early 1948 right-of-ways and post-1948 right-of-ways, which ones control. And the courts have held, if it's a valid right-of-way, it's a valid right-of-way. So as right-of-ways are expiring and or coming up for renewal, the BIA is pushing everybody through regulation into the 1948 Act. Some old, not here, but in the Midwest, when the new regulations came out, the BIA actually got sued by oil and gas companies for changing the regulations on them with how they could have oil and gas pipelines. They wanted to stick to the oil and gas right-of-way, the one from 1901. And so they sued the BIA for changing things up on them. But for now, and that was all resolved. For now, the regulations point to the 1948 law, which is in a couple of three sections. So 323 through 328. 323 is just the general right-of-way authority for the secretary to approve right-of-way subject to conditions set by the secretary. Thankfully, since then, the secretary has begun to defer to tribes, as you heard from the BIA. They'll defer to tribes on a whole host of right-of-way terms and conditions, but ultimately, it is the secretary's easement. This is an easement not between the tribe and the utility, or the tribe and the right-of-way holder, the grantee. Tribes are not parties to the easement. It's the United States and the grantee who are the two parties to the easement. So ultimately, it is the United States' decision to make on what the terms and conditions are of that easement. But it does require the consent of the tribe. And consent comes in many forms. Some tribes in the older days just did a resolution. Other tribes started to get a little bit wiser and started requiring agreements. My practice is an easement agreement to represent the consent of the tribe. Where the tribe is a party to the easement agreement does not have to be approved by the BIA, but it sets the terms and conditions under which the easement holder, the grantee, can be on tribal lands. And now there's a whole host of things that go into easement agreements, like here's what you can use the easement for, here's what you can't use it for, here's what the law, here are the tribal laws that will apply to you on our lands. Here are the taxes you're going to pay. Here's how we're going to resolve disputes, because that might be different than what the regulations say. So easement agreements are, for me, the way for tribes to assert their jurisdiction over you, the grantee. Otherwise, again, you're not a party to the easement. So the only way for tribes to protect their interests is effectively through easement agreements or something akin to easement agreements. So for me, that's what the consent is. We consent. The easement agreement says we hereby consent. And the other aspect of the easement agreement that I tend to do is we incorporate it into the grant of easement. So the terms of the easement agreement become, in part, the terms of the grant of easement. And that does two things. One, it federalizes the easement agreement. So now the BIA can actually enforce the easement agreement because they have the authority to enforce the easement. The tribe can't enforce the easement terms. They're not a party to it. But they can enforce the terms of their easement agreement, and then they can get the feds to enforce the terms of the easement agreement by incorporating it. So that's one way to resolve a whole host of issues that our Supreme Court has created for us in the context of who has jurisdiction over easements. Just compensation obviously is required. Who knows what that means? Lots of people, we've talked about appraisals. You know, appraisals are always wrong, especially on easements. You know, nobody gets paid for an easement. So there's lots of ways to negotiate that. And the BIA will, of course, defer to whatever the tribe wants to do. And there's lots of ways to be paid. So we're starting to see, for example, more payment outside of the easement. I know with regulated utilities, they have a way to limit what they have to pay, at least what they can recover. So we start to see side deals. And a lot of times tribes will, for example, work out community benefit agreements where it's a side deal with respect to the easement agreement, not in the easement, not part of the compensation, but something else that benefits the tribe. An example there might be, we get to interconnect to your power line. So I'm going to have the right to do that. I'm going to build a solar project on my reservation. I need an interconnection point on your power line. So this is part of the deal we're going to make. So you'll start to see a lot of that tied up with compensation and consent. And then the secretary has to issue their rules and regulations. I made a note of the Federal Power Act. FERC, of course, regulates hydroelectric facilities. FERC has the authority, and people who get hydroelectric licensing still have the authority to impose eminent domain for purposes of a FERC-approved hydroelectric license, including tribal lands. It's one of the only times somebody can condemn tribal lands is through a FERC-approved hydroelectric facility. So the Right-of-Way Act, because by the time we had a bunch of dams with a bunch of power lines on a bunch of Indian lands, and so Congress said, yep, we're not going to repeal that authority to put power lines on Indian lands without tribal consent. That's what the Federal Power Act does. So that right is preserved in FERC to do that. Okay, next slide. So everybody said a lot about those 4 bullet points. Some other issues related to individual Indian lands, allotted lands. There is still a remaining provision from the General Allotment Act, which allotted tribal lands around the country to allow for condemnation of allotted lands for public purposes under state law. So I don't think California has condemnation authority. I don't think your utilities can condemn land here yet. They can in other states. So the case I cite here is in New Mexico. New Mexico allows electric utility companies to condemn land, to take the land for transmission line purposes. They tried to condemn allotted lands on the Navajo Nation reservation. This law is still on the books. They're able to do that. Allotted lands in Oklahoma get condemned all the time, for example, because it's allowed. But there is a little wrinkle, and so I just wanted to highlight this case because generally you can condemn allotted lands, Indian lands, for purposes allowed under state law, unless the tribe has an interest in that allotment. And with a lot of the fractionation and the land buyback that happened after the Cobell settlement, a lot of tribes have actually bought into allotted lands. So if the tribe has an interest in the allotted lands, you don't get to avail yourself of that provision. Next slide. So the folks on the BIA talked about, speaking of allotted lands, the tribe's partial interest. Tribes are treated as a tenant in common, so even if they have an interest in allotted lands, they're treated like any other allottee. So a tribe cannot veto from a consent standpoint, an agreement on allotted lands. They are just one of all the other 500 people who might be on the allotment. So the ANILCA, the American Indian Lands Consolidation Act, ILCA, creates this, this sliding scale of how many allottees need to approve the easement, consent. And again, a tribe is treated, if they have an interest in that land, they are treated the same as any other landowner. And then as noted, the secretary can approve on behalf of certain allottees. So if you're dealing with a right-of-way that has a lot of allottees, and some of you in here are, you might have a big, long schedule. You know, if they're deceased and they haven't gone through probate, or if they're minors, a whole host of circumstances, the secretary can consent on behalf of them. And again, if the tribe has a partial interest, they can consent, but they don't have to. And if they don't, it doesn't kill the consent requirements, because again, they're treated as a tenant in common and no different than anybody else. Okay, next slide. So we've got all these different parts in the right-of-way regulations. I'm not going to go through these in a lot of detail, because we saw that process from the BIA side. Let me just talk about two aspects, though. So next slide, under the kind of key general provisions. You know, this covers a lot of infrastructure, right? So it covers transmission and distribution lines, but it doesn't apply to the Federal Power Act easements, as I said, access roads, pipelines. We're talking about broadband here, but a whole host of reasons why you would need a right-of-way from tribal lands. It does not apply to congressionally approved right-of-ways. So I don't know if you guys have any railroad right-of-ways here from the old Railroad Act. We have a lot of them in Arizona. So we're not quite sure what's going on out there, but it doesn't apply to those. The regulations purport to acknowledge that the tribes can retain jurisdiction over easements. There's a case out there, though, called A1 Contractors versus Strait, decided by the United States Supreme Court in 1997. Which treats effectively certain types of easements as fee land for purposes of whether tribes have jurisdiction. So the regulations say the tribes can retain jurisdiction if they want to. They don't have to if they want to. The tribes can consent or concede to state jurisdiction if they want to, or state law if they want to. So that's part of the negotiation of that easement consent. But just know that we've got some case law out there that makes it maybe a little bit more difficult for some tribes to assert jurisdiction over some easements, depending on the status of the easement. It also purports to not allow state taxation on easements, especially of almost all of its non-Indian infrastructure, and confirms the tribe's right to tax. But like the jurisdiction, consistent with applicable federal law, and at least in the Ninth Circuit, the Ninth Circuit has determined that tribes cannot tax certain types of activities on easements. So again, there might be some negotiation around what those taxes are, but we have to keep in mind that certain types of easements and certain types of taxes under the Ninth Circuit decisions may not hold. Now, that might change given some of the recent change since certainly 2000. We've had some recent case law in the Ninth Circuit that has kind of maybe backed away from how they look at easements, but we will see how that law continues to go. Next slide. So service line agreements. So one of the things I note in a service line agreement language doesn't say anything about broadband, doesn't say anything about fiber. Talks about the last mile, right? The line between distribution line and the customer's home. So a whole subpart on service line agreements. This is new to the regulations. When the regulations were updated, it was not clear whether the BIA had to approve service line agreements. And in part because utilities tended to treat even that last mile as an easement. And some of the utilities in California still treat that last mile as an easement. So, so the BIA at least did us a favor by calling out service line agreements in a couple of key ways. One, define them as true service line agreements from the road to the house, from the road to the building. Gave us some sizes by which we could say, okay, if it's 14.5 kV or less, then it's most of them are 6 or 12 kV, so we're well within that to get to the house or get to a building. But if it's for commercial or industrial uses, our casinos, or our government buildings, then it's 35.5 kV, or irrigation. I don't know if we have that out here. So we do at least have some size markers. And so, in my view, anything under these sizes is in a service line agreement, period. We're not talking about easements for EV charging stations. Southern California Edison. It's a service line. Why is it a service line? I'm not going to the BIA to approve an easement. I'm not doing it. I'm not going through NEPA. I'm not going through that process. If I can do a service line agreement, I'm doing a service line agreement. Nobody has time for any of that other stuff, and nobody's got money for it. So we want to take full advantage of service line agreements when we have the chance. We do need tribes' approval of the service line agreement before you can begin construction or use. And as indicated, BIA doesn't have to approve it, but we do have to file it with them. So let me end with just some things to think about, other key legal considerations. This question of scope of state versus tribal law and jurisdiction. So CPUC guy just talked about CPUC permitting of transmission lines, et cetera, the CPUC general orders, CPUC orders related to broadband access, right? From our perspective, none of that applies on tribal lands. None of it. No general orders, no requirement to put telephone lines on electric poles under CPUC rules, because California state law does not apply on tribal lands. California state law does not apply to federal easements. These are federal easements. State law does not apply to them. And so unless a tribe agrees that it will comply with the CPUC rule, the CPUC rule by default does not apply. So we've got regulatory issues, we've got taxation issues to work through. We got utility practice and rules that flow from CPUC rules, right? So the utilities have their own right-of-ways, they've got their own service line agreements, they've got their own tariffs. The example I give here is again related to EV charging stations, which a lot of tribes are doing, and some utilities practices that it's not a service line, it's an easement. Well, sorry, then I've got to go again to the BIA. I got to do NEPA for something when your rule is it's an easement. So how do we kind of start to figure out how to deploy resources and transmission systems or distribution systems more efficiently by taking advantage of the rules that we get to take advantage of that actually do apply to us? So with respect to service line agreements, whose form do we use? I negotiate lots of service line agreements. We start with the utility form, then we throw it out, and we go, here's our form. So, but there's a happy medium to be found, and I think this is really an area where, especially where there's, might be a good area for collaboration, especially with the BIA, right? We don't necessarily want one form fits all, but it might be helpful to have a service line agreement form across utilities that is not approved by the CPUC, because it's not their law that applies, but might be approved by the BIA to say, okay, this is a form that looks like it's going to do what it's supposed to do, and it makes it easier for everybody. We're not all negotiating independent service line agreements with independent utilities, and so we save the tribes time and money. Intersection with multiple uses, so this idea of putting telecommunications equipment on electric utility right-of-ways, right? A violation of the easement, can't do it. The easement says electric utility, that does not mean a fiber line hanging from your pole. And this is a huge issue, right? Because we want to use the poles. So if I've got an easement that's limited to electricity use, I cannot use it for broadband, not without amending the easement, which I might be able to get away with a CADX from the BIA if they're nice. But if I got to put up some more poles to do that, now I've got some issues, right? So we've got to think of some other ways to have multiple use. And if we know we're going to do broadband in the future, then maybe we draft easement documents that allow for future use with the tribe's permission. So you can't just slap it on and say, well, we have to do it. So we've got to think of some ways to get through how we know you have multiple use on current easement or future easements, and so we can avoid some of the issues. Fiber and roads is another issue. So with that, I think, let me just end with, I do think there's some opportunities for us, and these workshops are a great start. And so thank you to the CPUC and the tribes for joining in this, and the BIA for showing up, because I know it's not easy for the BIA to take a little bit of a knock on their processes, notwithstanding the 500 tribes or 100 tribes you guys have here in California. But I do think there are some opportunities for us to have some better collaboration around minimizing or mitigating the transaction costs around these efforts. Utilities got lots of lawyers who understand this stuff a lot better than some tribes do, of course, and lawyers are not cheap. So I think there's some ways, I think, for the three communities, the BIA, the tribes, and the CPUC, to work through, especially some of these intersection issues. How do we avoid problems in the future? How do we avoid people being out of compliance with their easements? Or we want to do this, but we can't because the easement doesn't let us. Or we think we might be a new way to approach the technology that we didn't think about. So are there some other ways for us to deal with resolving some of these differences in jurisdiction, in regulation, and oversight, but not to the point where we're killing our ability to deploy infrastructure on tribal land. So with that, are we taking questions or no? Later?
But I did have just two follow-ups when you're done. Before
I'm
we
done.
move on to
I'm
Michelle.
done.
Oh, okay.
Thank you.
Just two things that, one, utilities in California do have condemnation power subject to certain provisions under the PUC rules. On tribal land, though, particularly, there's case law regarding tribal sovereign immunity, so they cannot condemn land on tribal lands, but they do have that general power. And then two, I agree with you 100%. This is a good place to start these discussions. I think we can get to a middle ground. I do think we need to have a real discussion about the PUC regulates the utilities. So we don't regulate tribal lands or the tribes, but we do have an obligation to make sure the utilities are performing safely. So our rules do need to apply to them because it's an interconnected system wherever that system is, and they have the right to serve within the broader boundaries. So, but I think we have to have a discussion about what that means, and tribal consent, and where tribal rules and things that tribes need to see for that infrastructure when it's located on tribal land. So I agree with that, but I also would hate to see a situation where there's an impasse that prevents tribes from getting services or safe services. So I just want to put that out there as well.
Yeah, I'll just add, there's a difference between kind of the CPUC's safety general orders and their non-discriminatory access to poles sitting on Indian land orders. So, it is a trespass for someone to use Indian land without the tribe's consent and without the BIA approval. So when you...
And I know we're going to get to the questions. I don't disagree with you. Our requirements do not supersede federal requirements. I think that's important to say, and I think Michelle's going to go on, and we'll have a lot more time this afternoon to further the conversation.
Very good. All right, that's it. Who's next, Michelle?
Yeah, hi everyone. My name is Michelle Lee, and I'm a member of the Pit River Tribe from Northeastern California. I'm going to try to share, or maybe they have it already shared. I feel a little bit concerned about the time, and I want to make sure that, sorry, there's an echo. I want to make sure that Denise Turner Walsh has an opportunity to present. So is she there in the audience?
Yes, Denise is here.
Yeah, I mean, we only have 15 minutes left, and I would really like to defer to her. I think a lot of my presentation was covered, and I would like to defer to Denise to use the rest of the time.
And Denise, if you want to go first, we'll defer to you. And Michelle, we can go over a little bit. I know this is a very important panel, and we don't want to cut this short. We can figure out adjusting the schedule for the afternoon if we need to.
Okay, yeah, I just want to make sure that Denise has an opportunity to go through her presentation.
Okay, so
Thank you.
we'll move to Denise then, and then go back to you, Michelle.
I'll be quick. You want to put my slides up? Hi, everybody. I'm the Attorney General for the Rincon Band, and for those of you that were here in July, you might have heard some of this presentation. I've expanded it a little bit, but we'll try and ride through it. It's gotta go.
It's slide 93.
No, it's fine. All right, so you can go to the next slide. So the Rincon Reservation where we are today was established in 1875. I'm going to talk about the historical framework that was preceded the 1948 statutory framework that Pilar spent some time on, which is our framework today for all of the rights-of-ways in Indian country generally. So when the reservation was created under the Mission Indian Relief Act in 1891, you're looking at a picture of the reservation. This reservation serves as permanent homelands for the Rincon Band, and all of the reservations in this valley that we sit in also are Mission Indian Relief Act reservations. This reservation is about 5,000 acres. It sits atop a pristine aquifer with very clean water, very sandy loam soil, so we're very protective of the water source here. It's the water source for the entire basin. The Tribal Council for Rincon consists of 5 democratically elected leaders. The band is rather small, about 475 members. The Mission Indian Relief Act was the first source of right-of-ways on this reservation, and next slide so you can see the basin. On this reservation and many of the reservations that are here within the San Luis Rey Basin, the Paula Indian Reservation, Palma, La Jolla, and Rincon. And what you're looking at is the watershed, and the Mission Indian Relief Act actually authorized the first rights-of-ways for conveyance of the San Luis Rey River water. And what happened here under the Mission Indian Relief Act was it said that you had to have the Indians who occupied these lands, their consent in order to obtain a right-of-way for conveyance facilities across these Indian lands. And the other thing that it said was that if you did so, you had to make sure that there was enough water left for the Indians who occupy these lands for their agricultural and domestic uses. But what happened was 3 or 4 years later, in 1894, and in the early 20th century, the United States approved a series of contracts and right-of-ways that did not have the Indian occupants' consent. And what they did that for was to take water, dam up. You see the blue Lake Henshaw on your right there in the slide. And what that did was it dammed up the headwaters of the San Luis Rey River. And the result of that was diversion of 90% of the San Luis Rey River water from Lake Henshaw Dam through the La Jolla Indian Reservation, through canals. You can see it if you, at lunch, maybe look out. You'll see the flume going across the mountains behind me. It resulted in the diversion about 90% of the river water to the city of Escondido and Vista Irrigation District. Next slide. The next slide is a picture of Lake Henshaw and the dam. I'm standing on the dam in this picture, and on the right you see the beginning of the canal that took the water and diverted it outside of the basin. The water would normally flow through through Rincon, La Jolla, Rincon, and then north to Palma and the Paula Indian Reservations out to the Pacific Ocean. So what happened, next slide, was basically litigation resulted over these rights-of-ways because there was no water, and of course there was no consent. And in 1969, the Rincon Band, along with the other tribes in the basin, sued the city of Escondido and then joined Vista Irrigation District in the suit. These suits took 12 years from the time that they filed to get to the Supreme Court. The Supreme Court basically held that the consent provision, the Indian consent provision under the Mission Indian Relief Act was superseded by the Federal Power Act that came into being in 1920. Because remember, we're 1890s to 1920, and that Congress couldn't have definitely knew about that consent provision and basically overrode it. And the practical effect of that litigation was to restart, the practical effect of that decision was to restart the litigation after 12 years at the district court level. And the bands decided at that time to look for a congressional fix. So next slide. So they went to Congress instead of going back to the district court and starting over. They were successful. They were able to get Congress to enact the San Luis Rey Water Settlement Act, and that act required all of the parties, the two, Vista Irrigation and the city of Escondido, along with the 5 bands, to resolve their differences and disputes over the water through a settlement agreement that would be congressionally approved. The act paid the bands $30 million and gave the bands 16,000 acre-feet of supplemental water annually and established what we have today, which is a federal tribal entity called the San Luis Rey Indian Water Authority. The act was amended in 2000 to find the water to actually have wet water, not just paper water. And in 2017, the act became final. So next slide. So those are the early right-of-way saga in this basin and on this reservation and on the La Jolla Indian Reservation. The modern framework that we're all operating under that Pilar talked about is the 1948 statute. This statute, as she said, did not affect the Federal Power Act, so anything that was done under the Federal Power Act was carved out. And the Mission Indian Relief Act was one of those other statutes that was unaffected by the 1948 framework that we're operating under today. It's important to note that we talk about SDG&E or the IOU's internal policies and processes and the BIA's internal policies and processes, but you have to also remember that each tribe has its own legal infrastructure that governs its internal policies and processes by constitution. In some cases, tribes don't have them, but we do. And in our case, we have to have every right-of-way and every land assignment here in our constitution has to be approved by the general membership. And there's an internal bureaucratic process for that. So that adds to the complexity of getting valid, getting consent and getting valid right-of-ways approved. You're looking at a map that is a snapshot of what the right-of-ways look like today on the Rincon Indian Reservation. The green is all of the perpetual right-of-ways. The orange are compliant. Green and orange are compliant SDG&E right-of-ways on the reservation. Everything you see that's pink, red, or purple are non-compliant right-of-ways. They are where SDG&E has facilities that are powering or going through and powering the reservation, but they don't have compliant right-of-ways that have been approved by the Secretary of the Interior. And this has impacts for residential purposes, for broadband, and for the renewable energy projects that the band is currently developing. Because it's a lot of the area you see on the reservation that is impacted by non-compliant right-of-ways. The 1948 framework that is the general purpose statute. The first big development push on the reservation occurred in the 70s. The tribe built approximately 80 housing units. Most of those housing units were with a lease with an All-Mission Indian Housing Authority, which was a housing authority that the tribes had as a consortium authority. And that lease, Amiha obtained valid rights-of-ways for the vast majority of the homes that were built in the subdivision setting. But along with the subdivision setting, there were always a few outliers. There were homes that were not included in those subdivisions. And for those homes have non-compliant right-of-ways. And today, our housing stock on the reservation, at that time in the 70s, was about 80 homes were built. And today, we have about double the number of homes. So, and then go to the next slide. So what happens when we don't have a compliant right-of-way for new homes on the reservation is that these homes don't have service line agreements and they're not electrified. And some of these homes are dependent on diesel generators. And that's how they're getting power today. What we did was we sent tribal staff, because we're trying to fix this problem, and we're working very closely with SDG&E to get this resolved, to get these homes electrified and to get our projects, our governmental infrastructure projects built. But what we did was we sent tribal staff to BIA, and they copied all of the BIA right-of-way files. And when we did that, we hired surveyors to draft the maps and go out into the field and figure out where the facilities are and see what matches what and where are the gaps. And that was the map that you saw. When the surveyors went out into the field, they realized that there were many facilities that didn't match the legal descriptions. In some cases, some of the variations were up to 10 feet from the center of the right-of-way. So we had to correct, and we're in the process of correcting all of that. And we have been working with SDG&E and BIA, but we believe that they are under-resourced for the amount of work just on this tiny little reservation of 5,000 acres. And what's happening is that the deficiencies of these gaps are largely falling on the Rincon Band tribal government. Next slide. As I said, some of these right-of-ways that are not approved, we can't get service line agreements, so these folks are on generators. To the extent our broadband project is, the design of our broadband project is using co-location on utility poles that don't have compliant right-of-ways. That's a problem for us because that has to get fixed in order for us to go forward. And then next slide. And then the largest project probably that we're doing, and we're really close to construction right now, is our microgrid project. The Rincon Band has been developing these microgrids since 2019. We're going to add a total of about 1.8 megawatts of renewable solar energy. And we're doing this because we want to increase our reliability to power for essential facilities on this reservation and reduce the cost to the government for energy. Between 2017 and 2019, the public safety power shutoffs that occurred over 18 times, some of which were short, but there were a few that were of long duration. And those that were long, between 12 and 34 hours, required total evacuation of all employees and patrons from the resort. This is thousands of people. We employ 1,400. And then we have the patrons there too. We have 1,000 hotel rooms. So they all had to be evacuated. Our north and south water system went down. We have since put these on generators. So we have backup power now, but at the time we didn't. And and our wastewater treatment plant went down. And for those of you that know that tribal governments operate in a commercial context because we don't have a tax base, 90% of our budget or more is dependent on the revenue from the casino. But because of these long duration PSPSs, none of which were 36 hours or more, they were not covered by our business interruption policies. So the government took a huge revenue hit. So our microgrids are part of our solution so that essential facilities can stay on during PSPSs. But they're also super time sensitive. And they're time sensitive because this new Inflation Reduction Act puts tribes on an equal footing with a private investor through what is called the direct pay option. Our project is 50% dependent on the direct pay option, and we need to reach PTO by the end of 2025 in order to file for the direct pay in early of 2026. Otherwise, we have to carry these financing costs for the whole next year, and that's not budgeted. So next slide. So what we're looking at, and we're working with SDG&E to figure out, is this is the timeline for us to work with SDG&E for any needed upgrades in order to support a permission to operate by the end of 2025. And we are in mid-November of 2024. This is the timeline as we understand it right now. So we submit 90% design plans for these microgrids to SDG&E, and it takes 16 to 18 weeks for SDG&E to prepare their preliminary plans. And then another 3 to 4 weeks. This is all sequential with the exception of the 3 to 4 weeks for final design and the 16 to 24 weeks for land surveys and environmental reviews for non-compliant easements. This is a lot of time. And there is no time frame tied to once we have final designs to actual construction and installation of any needed upgrades so that this is a go. You know, these are really complicated projects. They have a lot of parts. They have a lot of internal teams at SDG&E. We've got our consulting design teams. We've got supply chain issues. So really, you know, I think that there's a lot of opportunity for better coordination for broadband and for microgrids and for electrification of residences here. And I'm just hoping that, you know, in very short order, we're going to be able to work together so that it's not sequential, that some of these phases can be concurrent instead of linear. And, you know, the tribe's going to do what we can do to shorten the BIA timeframe. Morongo is not here today. They are an example of a tribe that is exercising their sovereign authority to issue temporary access permits under federal law. There's a statute that says you can encumber federal land up to no longer than 7 years without secretarial approval. And what Morongo has done is they have instituted a tribal legal framework to give the utility this temporary ability to go in and install without waiting for BIA approval. And that's, you know, 60 days. I mean, that's not that long, but they're doing what they can with the tools that they have. So thank you very much. And I guess go back to Michelle.
Okay, great. I'm glad we got to hear from Denise.
Go ahead, Michelle.
General. Yeah, I just wanted to, I'm going to try to skip through some of these slides because we covered a lot of the same information. And if someone could mute the feedback, that would be great. All right, so we can go into the next slide. I'm going to skip through these really quickly because many of these have been covered in great detail. So I think the points that I wanted to make, just to fill in some of the areas that I think are important that tie into both Pilar and Denise's presentations are, we know what trust land is. We can go to the next slide. The one topic that I want to talk about though is the TSR. So the title status report. If there is a right of way, if there is a service line agreement, it's going to be on the TSR, on the title status report. We know what a right of way is. We've talked a lot about it today. We can go to the next slide. We have easements. There's been a lot of discussion in the panels about easements, rights of way. A lot of times they're interchangeable. We refer to them in the common ways. Let's go on to the next slide to get into, maybe skip over to title status report. The next slide. So the title status report, what it does is it shows all valid recorded encumbrances that are on tribal trust land. And one of the concerns that is raised in the material, the information that the Attorney General just stated, is that there's infrastructure on Indian land and trust land that isn't necessarily documented. And what Pilar talked about is trespass. And we see this as practitioners in Indian country, that there's a lot of infrastructure that is located on Indian land, but it's never been recorded. There was never a right of way and there was never a service line agreement. And so what happens is, particularly relating to the last panel on where they talked about the middle mile, the underlying infrastructure may not be properly recorded. And so as a result, when tribes are doing something new, or the state is doing something new, or utilities are doing something new, what it does is it puts a spotlight on the fact that the infrastructure was never properly recorded. There's a system, it's the BIA Land Title and Records Office. It was referenced earlier, but I just wanted to really highlight this is extremely important, because sometimes I'll, like a situation with a client where there is PG&E infrastructure in Northern California that's there and is being used and is being upgraded, and the question that comes up is, well, was there anything ever recorded on the TSR so that the United States is aware that PG&E is there? And if we pull the TSR, oftentimes that it's not listed. And then my question is, well, where was it recorded? Was it recorded with the county? And sometimes it is, and sometimes it's not. But having something recorded with the county has no effect on the ability and the rights on Indian land. So next slide. This is an example, just quickly, of what a title status report looks like. So it highlights the tribe, their status, the status of the land, and then we can flip to the next slide. There's a few slides that we can just sort of see that this is some of the content. It just shows how much acreage is there. If you go to the next slide, if there were any encumbrances, it would be on this slide or the next slide, and we don't see any. So if there's any infrastructure, and we can go to the next slide. If there was any infrastructure on this property, it's not reflected in the TSR. And so the question is, how is anything there if in terms of economic development, or even offices or buildings, how is anything on this property if there's no infrastructure that's identified? Next slide. And that results in some of the problems that we have today, where now you have just regular infrastructure for housing, and in order to bring power to the homes, like at Rincon, you've got to completely you've got to get compliance with your power company and your utilities for them to complete a right-of-way package. And that is not an easy thing to do because many of them do not understand that it's their responsibility and they are the applicant. It was discussed, Laura discussed roadway easements and the statute. Next slide. The Caltrans presentation was interesting because I understand that the focus there was on encroachment permits. But one of the things that we see is that, and I'm sorry I have my dates wrong on here, but the Caltrans right-of-way could be established under the 1901 statute. And if so, then other utilities can go in that easement. But if not, if it wasn't under the 1901 statute, then the utilities may not install infrastructure in the easement, but have to get their own right of way. And so this is another level of real property title examination that needs to occur in order for the utility and the tribe to determine if a right of way is needed. With Caltrans, their easements are not mapped necessarily accurately, and there may not be a recorded right of way on the TSR. And if there is a right of way on a TSR, there are times when the line goes on and off the Indian land. So I don't want to really name specifics, but there was a project in Northern California where the utility PG&E had what they thought was a right of way because they had gone into the Caltrans easement, but it was unclear whether they were able to do that legally because under the regulations today, you can't piggyback. And so the question was, what was the statutory authority for the Caltrans right of way? And then was all of the infrastructure actually in that right of way? And in some cases, Caltrans thought that the road was completely outside of Indian land, but in fact, some of the easement and the utilities were crossing over into the reservation. And so the lines may not be really clear. And if they're not, the best way to clear that up, if you have a line that is where all the parties believe that it's on fee land and not reservation, but some of the poles are on Indian reservation land, then the right of way should be done for the whole line. And that's something that will take significant amount of time. Next slide. That was really my main point that I wanted to make, is that there may not be a valid recorded Caltrans right of way at all on Indian land, and if there is, that doesn't mean that the others can fall under that easement. Next slide. This is just a chart depicting about the various ways that a right of way could have been authorized. So there's the 1901 Act and the 1948 Act, which Pilar's discussed. And if it's under the 1901, then there's not tribal consent required. But if it's authorized by the 1948 Act, the tribal consent is required. And so that's an important distinction. And next slide. Actually, we could skip the next slide because that was covered. The broadband and fiber was covered. And then what I wanted to focus on was just an example. And I know you're in Southern California, but I assume some of these issues occur down there with the other utilities, which, as I mentioned, there would be a number of tribes. There's 52 tribes in PG&E's service district. There's 110 tribes in the state, so I would venture to guess it's a high number of tribes in Southern California, at least 40 tribes in Southern California. And all of those tribes that have tribal trust land are served by some utilities, but we would need to make sure that all of those utilities are covered in either recorded service line or right of way. and the TSR would need to be looked at. And if not, then you need to initiate a right-of-way application. And a right-of-way, I skipped over a service line agreement, but it was talked about earlier that you have if you have a right-of-way for utilities, and then you have the ability to sort of take a line split off from the right-of-way into individual service for, say, homes. Those could be service line agreements, and those don't need a right-of-way, but you do need the right-of-way for the initial infrastructure. And maybe we could skip the next slide and just navigating the process. There's right-of-way documents required, requesting the title status report, having some kind of process for reviewing the application for a right-of-way. So say the tribe is successful in getting a utility to come to the table and negotiate a new right-of-way. Not having, if there's not a team assigned to that right-of-way application development, it's going to take a really, really long time, because what happens is we get kicked from one person to the next, to the next, to the next within the utility, because there may not be, in my experience with PG&E, is there's no tribal team. They have a tribal liaison, but when you have the different regions that are all served by different kind of districts of the utility, the different districts have different people that are working on tribal issues, rather than there being just a tribal department. And if there were a tribal department that served all of Indian country, that seems like that would be more efficient, because all of the tribal applications would be going through folks that understand and know what's going on, and understand all the information that was shared today, versus the tribes continuing to be interfacing with staff that have no idea what we're talking about. And we can literally lose a year or two being passed from party to party. I know I have a service line agreement that I've been trying to complete for a tribal client in Northern California, and I think we're into year two, maybe almost into year three, just because of staff turnover. And once we get somebody educated, they leave. And right now, I'm not even really sure what the holdup is, but the only recourse I have is to keep emailing them. And I don't even know if the person I'm emailing even works there anymore, because with the utilities up here, we don't necessarily see a out of office, or that they're not there anymore in a forwarding. They just don't respond. So having an application process would be really helpful, and a way for the Department of Interior to interface. And I think they do interface with the applicant, but when they interface with the applicant often hears what they want to hear, and then they come back to the tribe and say something different. And so we kind of go around in circles. So there's not really a good way to collectively, cohesively navigate the process. Next slide. I know everyone's probably ready to go to lunch. The main question that seems to be a cause of consternation on my part is, who is the applicant for the right-of-way or service line agreement? The utilities seem to still want to think that it's the tribe that's the applicant, because we want the service, but it's not. It's the utility, as was explained earlier. This is between the utility and the United States government, because the United States is the owner of the land. And so the utility just somehow needs to completely understand that this is the United States government that they're dealing with, and the tribe is the beneficiary. And Pilar talked about how tribes can exert their authority in that process to get some enforceable rights, but the utility has to develop the right of way. And so all the tribes can do is try to aid and help and assist and encourage, but the NEPA documents and so on are the utility's responsibility, which is often why they never happen. The next slide is dealing with compensation. And compensation, it was touched on already. It's required under 25 CFR Part 162, but it can be waived in certain instances. So obviously, if it's a commercial operator that's going to be taking broadband or AT&T through an Indian reservation, we generally do negotiate compensation. And it can be pretty significant compensation because this becomes an asset of the tribe's lands. And there can be other forms of compensation that was mentioned earlier where you have, a connection point or access to services or access to power. But those agreements are very challenging and they take a long time. So sometimes financial compensation is the easiest way. But of course, we're not going to be asking for compensation when the tribe just needs service. And next slide is just where do we go from here? And I think I've repeated myself enough to kind of bring home that the first step is to identify what's there on the TSR. And if there's infrastructure on the parcel and there's no recorded encumbrance on the TSR, then the parties have to work together and determine, is it a service line agreement? Do we need to do a right of way? And they need to work together to develop that infrastructure and those legal entitlements, or else, we're just kind of kicking the can down the road a little bit longer. And it would be great if these issues could be resolved today and not handed down to the future. So especially with middle mile and all that's going on and last mile, this is a good opportunity for us to clean the slate. And that's the end for me. So hopefully everyone can get some lunch and I'll be here if there's any questions.
Thank you, Michelle, and thank you to all of our presenters for this morning. We are going to go ahead and break for lunch. There is lunch over to my right, over on the side here. So it's all brought to the room, and I want to thank the Rincon tribe for working with us and providing the food today. And we're going to break. We're going to take a shorter lunch till about 1:20, unless there's any objections, if that works for folks. Okay, great. And we're on break till 1:20.
Writers' presentations. All right, we're going to start with Southern California Edison. I'd like to invite Larry Chung and James McKenzie up for that presentation. Thank you.
All right, thanks very much. My name is Larry Chung. I'm the Vice President of our Customer Engagement Division at Southern California Edison. I'm joined by my colleague, Jimmy McKenzie, who will be up here in just a second. I wanted to kick off, if we go to the next slide, please. Just a little bit of introduction about SCE, given that this is a different service area we're in today. We cover approximately 50,000 square miles in Southern California. We serve 15 million customers approximately, over 40 tribes. I think you heard earlier in a previous presentation, 13 of which are federally recognized. So we do have a large tribal footprint in our service area. I think I want to cover a little bit about some common sort of requests, both from SCE to tribes as well as from tribes to SCE as they pertain to right-of-ways, since that's the topic that we're here to discuss. First, I want to talk about covered conductor. So I think unless you've been living under a rock, you know that the last few years our state has been plagued with wildfire and the risk of that catastrophic wildfire. And so as utilities, we've had to really look at our risk profile, look at how we are operating safely, and making sure that we're partnering with our communities, our cities, governments, local, state, federal, and certainly our tribal partners. So our covered conductor program is really to install these covering conductor is such a technical term. It's basically coated wire to help prevent the sparking or ignition of wildfire due to utility electrical equipment. And so over the last several years, we've had a large focus on that program. And we see that as one of the most important and affordable mitigation methods to reduce wildfire risk associated with sort of contact-related faults in our overhead conductors. And so that is something we partner with our tribes, our tribal partners, to make sure that we're getting good communication, getting permission to go in and install these covered conductors across our service area. The next one is targeted undergrounding. So I want to call out that we're targeted because it is truly that. We have an obligation and a responsibility to serve safely and serve affordably. And so when we look at undergrounding, this is not a one-size-fits-all solution. We really try to look at where it makes sense, where our most high fire risk areas are, where sort of the mitigation that is accomplished with undergrounding would be best served for our customers, for our communities. And so the Targeted Undergrounding Program, known as TUG, this is really to make sure that we are burying those lines where we see the risk at the very highest and have the highest potential for wildfire ignition. And again, that is an area where we have to work very closely with our tribal partners to make sure that we have access and that we're able to upgrade and bury those lines where appropriate. The next area is around deteriorated poles, replacement, and ops and maintenance. Jimmy's going to talk a little bit later on about some of the challenges we face with this, but this is an area where we have to maintain our infrastructure and make sure that we're operating safely, and so we make sure we're communicating with our tribal partners to get access to areas where we need to in order to maintain our infrastructure, replace where we need it to make sure that we are operating safely. That's not without challenges, and like I said, I think Jimmy's going to talk about some of those later, but that is an area where we have to be in very close communication with our tribal partners. Likewise, vegetation management is an area where we need to do brush clearing, tree trimming and removal, and all of these requests also need to be reviewed and approved in concert with our tribal partners. This one is actually can be really sensitive as well, both in tribal areas as well as non-tribal. I'll tell you, I have just a little under 4 years at the utility, and one of the first things I had to learn was, you have to be sensitive about lands. You have to be sensitive about vegetation. There are, different meanings, and there are different sensitivities associated with flora and fauna. And so that's something we take seriously. We have arborists, horticulturalists to make sure that we are following standard guidelines, that we're making sure that we're not harming land. And so we don't always get it exactly right, and trust me, I hear about it when we don't get it right, but it is something that we take seriously, and it's something we need to do to make sure that we're maintaining safety and preventing the potential ignition of wildfire. On the tribal request side to SCE, this is not comprehensive, but I did want to cover a few. So you've heard a lot today about service line agreements, and so that is something that I think Pilar and others talked about this earlier. That is something we do with our tribal partners, especially if we're trying to connect single resident, smaller customer. Sometimes it requires an easement in other instances, but SLAs are absolutely something that we engage in with our tribal partners. Another area where we get a lot of requests are around development. So 2 examples in recent history with Agua Caliente, we had the casino in Cathedral City, where we have to work together on those requests to get interconnections and make sure that they're getting served. Morongo is another example. I don't think Morongo's here today, but they've had multiple service line extension requests where we've been able to work together on those, and I'll cover later on some of the successes we've seen as well. I'm sure you've heard of the West of Devers project as well, so that's just another example. But development is an area where we get a lot of requests. Generation and battery storage, I think there was an earlier presentation I had just walked in. You were talking about microgrids and things like that. So, when we look at the ability to have a redundant, resilient system, and we talk to our tribal partners around generation, battery storage, and just general resiliency measures, that is also an area where we receive a lot of requests. EV charging stations, another area that you heard about earlier today. This one's tricky because, we, whether it's an easement, a service line agreement, whether it's something that the tribe wants to initiate, whether it's something that a customer like a Tesla might want to initiate. These are all complexities to EV charging. And of course, we want to be in line with state policies and making sure that we're moving that forward as well. So that is also another area where we've seen an uptick in requests. And then lastly, tribal land transfer of property. We want to make sure we're following our state mandates on that and our guidance on tribal land transfer policy. So those are just generally some areas, I think, both from the SCE to tribe request side as well as the tribe to SCE side that I wanted to cover. And I know Jimmy's going to talk about some of the environmental aspects in our right-of-ways as well as some challenges. And then we'd like to get to successes and some of the happy things too, because we want to make sure we're painting the full picture. So with that, Jimmy, can I ask you to come up?
Thank you, Larry. And thank you. Again, I'm Jimmy McKenzie with Southern California Edison's permit. It's a new organization, so we tried to get the longest name possible, permitting joint pole authorizations and real properties. So, as Larry mentioned, next slide, please. I want to share, and a setup to this slide is we're here because we want to improve the partnerships. On this slide, this is our intended practices for environmental and cultural analysis and work authorization, and it's something that as we implement any process, sometimes there's misses, and so sharing that here, hoping that we continue to have dialogue, thoughtful discussions, and process improvements. So if there's areas where we're missing the mark, we want that feedback. We want to make sure that we're continually getting better every time we do one of these projects or anytime we interact as well. So with that, kind of some groupings on the bullets here. The first couple show the is the microphone not working well? All right, is that better? It's not, is it me? There, is that better? Okay, all right. I'll get closer, sorry. Okay, so on the first couple bullets there, we're looking at the requirements that for, we follow NEPA and CEQA depending on whether it's the proper jurisdiction for either. And then we look at, we develop mitigations. That's the next couple bullets we have here, and I won't read them directly to you, but we have mitigations to protect species, historic sites, habitats. We use a bunch of very qualified consultants to provide us guidance on that, and that goes into the work orders and the guidance to the crews that are performing the work, whether it's Edison crews or contractors. And then we also have an environmental requirements document that's given to the construction teams, and it's something that they're expected to follow along the way. So we have, and those environmental requirements documents are provided. The way our department works is we have the environmental group provides these mitigations and this information. It goes to our government lands team, which has an area, and there's several individuals that are responsible for those relationships with the tribes. And they package the information, provide it, and put all the work requests together. So, and then also just a note at the bottom regarding most of our operation and maintenance activities are statutorily exempt from some of these processes. So that's our high-level process, and we can look at Q&A later if there's any questions about it. Next slide, please. As Larry mentioned, just wanted to share a couple high-level challenges. Again, we know there's Q&A, and we can go into more detail, but just at a high level, wanted to share. And hearing some of the presentations earlier, it sounds like our challenges are pretty similar with what we've been hearing about. The first is the long lead times regarding the service line agreements, and that there's additional facilities, there's other processes that can be involved as well. And so, for us, it's typically 30 to 45 days is what we're hearing from to process from the initial request. So the timeline can be longer if we see the service line connection requires additional facilities to be installed due to the location of the other distribution assets. There's also planning, environmental review, rights analysis, and other pieces that can add to that processing time. So the next one that we have there, excuse me, is the O&M request, delays in processing some of these O&M, operation and maintenance requests that we have many requests. We understand that, and right now a common theme with any agency that we're working with, as well as ourselves, is staffing. So we understand that, and we want to make sure that we're engaging in dialogue to discuss challenges around staffing, that we can work with the tribes through those challenges, because it's, like I mentioned, it's pretty common with any governmental agencies. It's common within the utilities as well, that there just doesn't seem to be enough resources for a lot of the work at times. And so one of the things that we're trying to do on this is to help prioritize, to hear from the tribes, what are your priorities, so that we can make sure we're taking that into account and sharing our priorities as well. Another area of challenge is scheduled outages. And so we do know that there's been requests associated with tribes being notified for outages. Also, unforeseen circumstances. We had a scenario where on the Saboba lands, the day before an outage at 4 p.m., we were notified that the tribe needed to cancel the work due to a death. And so we were able to work with the affected contractors, get the planning organization to stand that work down so that we could be supportive of the tribe at the time. And so also multi-agency delays for projects. It's when we have a lot of agencies, there's a lot of coordination, and a lot of times that can lead to delays as well. So those are some of the challenges. Happy to entertain more discussion on those as we get into the Q&A session, as well as we're working towards solutions on those and want to partner in doing so. And with that, I'll bring Larry back up to talk about some of the accomplishments.
If you notice, he got the challenges, I get the successes. That was by design. I get to talk about the fun stuff. So I mentioned some of these earlier, but I wanted to give a little bit more depth and detail. And I think, the solution, you're going to say, well, of course, but it really does work. And what I mean by the solution is all three of these examples that you see. Do we have it on? Next slide, please. On the slide, really started with excellent communication and had it throughout. And so I think when we see communication breakdown happen, we see, I heard, on some of the previous presentations, 1 year, 2 year, 3 year, really drawn out timelines. And so we try our best to make sure we're kind of front loading and we're making sure that we're soliciting feedback early on. In the case of Agua Caliente, this was early on in the pandemic. We removed more than 20 poles, and that happened within 6 months, which is, I think that's pretty fast. We worked really closely with the tribes and their cultural departments, and we had direct communication between SCE and the tribe, and we had in-person site meetings where we'd actually go and see the area that we were talking about. So it's very different to see it on a Zoom or a team screen. In fact, that's why I'm here today, because I know there was a virtual option, but I think it's different when you come and you see things in person, when you address people face to face. That's something that we take very seriously and pride ourselves in, and I think it changes the relationship dynamic as well. And so for Agua Caliente, we were able to kind of move that forward in a very relatively quick period of time, I think, because we had good upfront communication and then maintain that throughout. With Morongo, and I want to be clear, none of these are without challenges and bumps, but we got there. And with Morongo, there was multiple service line extensions for many of their new builds. We've had a partnership with Morongo for many, many years, with their tribal leadership, with their administration, and we were able to complete most of these within a period of 3 to 6 months, which again, I think, when you look at SLAs and you look at the work that needs to be completed, that's relatively fast. And again, I think we have established relationships with West of Devers and other projects. And so I do think gradually over time, and hopefully it gets stronger and stronger, we really try to build trust. We try to build that collaboration and communication to show that A, we do care, and B, that we're here to actually move forward and get work done and really try to meet the wants and needs of our tribal partners. The last one with Saboba, we had 20 plus outstanding projects within their lands, And Saboba took the time to meet with us. Now, this one's really interesting because we took a little bit different approach on this one, and we actually asked them how we should proceed. I think oftentimes as utilities, we have our processes, and that's not to say that we don't need those. We absolutely need processes, and there's a reason we have them. But I do think where we can have some flexibility, and so long as they don't compromise, anything like safety or affordability, anything like that, we can get creative. And we tried to get creative on this one, where we actually solicited from Saboba and said, hey, how should we approach these projects? What input do you have for us on how to best submit the work for our review? And then we were able to hear, here's, from their perspective, here's what we think. And then we were able to then share, okay, well, based on what you said, here's our perspective, and then come to sort of a middle ground and meet in the middle. And again, it doesn't sound sort of earth-shattering, I think, to say, hey, you have to have really good communication. I think that's a pretty baseline requirement. But these are 3 examples where that actually made the difference, where we did have very good communication. And we don't always hit the mark. In fact, we miss it many times. But I think having that open line to ensure that we're going to try and make right what we've messed up on is really crucially important. I think it was Michelle Lee that mentioned earlier, she wishes more utilities had sort of like a dedicated tribal team. I think actually we're in SDG&E's service area, and I think they do a phenomenal job of that. And we are trying to sort of emulate and see where we can actually have dedicated tribal resources as well. In fact, sorry, Roger, I'm going to call you out. Roger Jung is on our team there. He actually has folks within his team embedded that are specific dedicated resources for tribal relations and issues, along with, we have Amy Olson and Aaron, I see you back there too, who are our tribal liaisons. So while it's not maybe fully fleshed out, as Michelle was talking about, we're trying to get there again. I think San Diego does a great job at that. And so we are trying to figure out how we can have those dedicated resources to make sure that we're moving the issues forward that we need with our tribal partnerships. So I know we have Q&A coming up. We've brought all the people I just called out as subject matter experts to answer any questions we may have. Maybe, Jimmy, later you could talk about specific solutions we have for the challenges that were mentioned. But we wanted to take today to give just a general overview of Edison, kind of our structure, some of the environmental issues, our concerns and challenges, give you a little flavor of successes, and then of course we'll be available for Q&A afterwards. So I appreciate the time, and thank you for inviting us to be here today. Thanks.
Thank you both. And now we will move on to the next presentation, which is from, from San Diego Gas and Electric.
Let's see if I can get this right. Oh, can you all hear me? Great. My name is Estela de Llanos, and I'm the Chief Sustainability Officer and the Vice President of Land and Environmental Services for SDG&E. I want to start by thanking the Rincon Band of Luiseño Indians for hosting us today for this important workshop. And I also want to extend a thank you to Commissioner Hauk and your staff, Amanda, for coordinating this workshop together with the BIA and for bringing us together with the tribal nations, other utilities, other agencies to discuss rights of way on tribal lands. I cannot tell you how deeply we appreciate the opportunity to be here all day to listen and participate and see how we can grow from this experience together today. As I set the tone for the other speakers who will be joining, I invite you to reflect on 3 themes that came to my mind as I prepared for this: transparency, stewardship, and collaboration. We are here today in transparency. We've been asked to speak to aspects of our process, and we will be doing that. My colleague Jennifer Summers We'll be going through the steps that it takes on the SDG&E side for the right-of-way acquisition process. But we also are here transparently to understand how we can continue to grow, how we can continue to improve these processes. You've heard a lot today in somewhat excruciating detail just how complex it is to secure right-of-way over tribal lands, and that's for many, many reasons. I am confident that we can do better. I am 100% sure that there are opportunities for improvement, and we are here to explore that with you. And we will be here tomorrow and the next day and for years to come to continue to explore those opportunities. The second theme I ask you to think about is stewardship. And for this next slide, please. We, of course, recognize that each tribal nation is sovereign and we respect their laws and governance structures. And we also appreciate your relationship to the land and knowledge sharing as the original stewards, and these are your ancestral homelands. We have been around for about a minute of your 10 to 12,000 years here. We've been in operation for 140 years. It's not a lot of time in that context. And yet, this is the region, the unique and remarkable region, where SDG&E is privileged to do business. Some unique and remarkable characteristics of this region are the drivers for that complexity that you heard about when it comes to approving right-of-way, obtaining right-of-way over tribal lands. We have 17 federally recognized tribes in our service area. That's more than any county in the United States. We have tens of thousands of known cultural resources that are recorded, that we pay attention to, that we work to be good stewards of. This is a known biodiversity hotspot. There are over 200 imperiled plant and animal species in this region. And by the way, many of those environmental resources are also cultural resources, and that is something that SDG&E understands and appreciates. 60% of our service area is some other public or government land. And that land may be held for purposes as diverse as military readiness, or wilderness, or public access, or conservation. And those are responsibilities that we as stewards take very, very seriously. We also have a high fire threat in this region, unlike any other. 2/3 of our service area is within mapped designated high fire threat districts. And so we are stewards of public safety, and we take great steps, some of which are very painful to us and to our customers, including the PSPS events that you heard about earlier today. We do not take those lightly. We do not want to cut off power, but we do so when we need to, and we do so because of the public threat related to that high fire threat district in our service area. So we work very hard to balance all of these considerations and be stewards at the same time of the rates and the dollars that we collect from our customers. We try to be efficient, and we try to be mindful that we are balancing all of these considerations with the privilege of serving our customers, including our tribal customers. So the third theme I asked you to think about is collaboration. Next slide, please. It's very easy to think about collaboration as an external exercise where we work with the tribes, the CPUC, the BIA, Caltrans, other customers, to be good stewards of all of the constraints and resources that we have within our very unique and remarkable region. We do try to collaborate, and we will continue to collaborate with our external stakeholders. But we also want you to know that we are also working very hard to collaborate better internally. One of the biggest challenges we have is our own silos. And I think you've heard that from many of the speakers today. Different responsibilities within the same organization can lead to many, many handoffs that then translate into incredible frustration to our customers and to those same stakeholders with whom we're trying to collaborate. So you will hear today from my colleague Jennifer Jett about an initiative that we have launched internally that is not a separate department within SDG&E, another separate department within SDG&E, but rather a cross-functional working group that will meet with regularity so that we can have the visibility and the attention and the focus that we need to break down the silos that exist within our company and to look for those opportunities for continuous improvement. We very much, in that spirit of transparency, want to hear from you about the pain points that you experience and how we can examine our own processes so that we can make those processes better. I'd like to invite all of the SDG&E representatives here today to just stand so that you can be recognized. And if folks have questions today, these are our subject matter experts that we have brought who have been listening and are continuing to listen from land services, environmental services, tribal relations, design and project management, and cultural resources, as well as our right-of-way team. Thank you all. My colleague Jennifer Jett is now going to describe a little bit more of the initiatives that we have launched and put into place before handing it over to Jennifer Summers from our DPM organization.
Thanks, Estella. Can everybody hear me okay? Well, thank you. Good afternoon, everybody, and thank you, Estella. Thank you to the Rincon Tribe for hosting us today. Much appreciated. Thank you, Commissioner Houck, and everybody else for encouraging us to continue this dialogue. I think it's really important that we are, again, going on the theme of collaboration, continuing to have this conversation. I echo Estella's sentiments. This is, I'm Jen Jett, our VP of Operations Support and Tribal Relations. I've been with the Sempra and SDG&E family of companies for 20 years. As Estella mentioned, we have, since the last time we all got together, made some improvements and taken on various actions, but there is still room for improvement, as there always is. I want to reiterate that SDG&E is taking all of the concerns that we heard about then and that we've heard about as ongoing issues. Most importantly, at least from my perspective, is the delays that have been experienced in getting power and interconnection and new business. So I'll talk a little bit about that today. Those improvements that are already in flight will be called out specifically by Jen Summers. Before I get into some of those examples and talk about the initiative that Estella referenced, I'll just share briefly a little bit about my background. From a very early age, I was heavily influenced by the Dene worldview and spent a lot of time on the Navajo reservation with my dad, who taught at UC Davis for 40 plus years in cultural geography. So every spring and summer, we would go and I'd spend a lot of time there with my Navajo family. That stewardship that Estella talked about is something that's near and dear to me. So as I went on to college, spent a lot of time with the tribes working on tribal issues, went to law school. I like to say I'm a recovering lawyer because that's not what I do anymore, but I was a clerk for the Hopi Appellate Court, helped write opinions, tribal federal law issues are near and dear to me. And so both professionally and personally, a lot of the issues that you've heard about today, sorry, I feel like I'm getting some feedback. A lot of the issues that you've heard about today, it's sort of full circle that I get to in my current role at SDG&E, deal with some of these issues. So it's, I feel fortunate. I think it's a gift that on a daily basis I get to help move us forward as a company. So again, that's just some brief background, and it's partly to just share that it's a personal commitment, it's a professional commitment. That initiative that Estella talked about is a way for us as a company to make sure that we're not working in silos, that it's not just a land issue. It is not just a tribal relations issue. If you can go to the next slide. So I want to kick off a few of the things that this strategic initiative is trying to address. When we get together, the first thing we did was try to scratch out on a piece of paper. I mean, literally stood up on with a whiteboard and said, what are all of the issues that we hear about from the tribes? You know, obviously I mentioned interconnection. We talk about right-of-ways. That's why we're here today, to figure out how we can improve that process, what it is that is a redundancy or a holdup, where we can be efficient. I know Denise showed the timeline of how many weeks and how many days it takes for the application process. It's not okay that somebody waits a year or more to get power to their home. In no scenario is that okay. So when we're hearing about that, this is not an exercise in finger pointing. It's sort of a holistic view of where along the timeline can we be more efficient? Where along the timeline do we actually have control? Where we don't have control, where can we partner and figure out a way to improve that process or get rid of a piece of the process that's not necessary or not in the best interest of the tribe or the homeowner or the business owner. Over the summer, we put this initiative together with this cross-functional team to really focus on identifying those problems, proposing sort of improvements and solutions in areas like acquisitions of rights-of-way, protecting the cultural resources that you've heard about today, implementing those process improvements, and really kind of prioritizing which ones we needed to do sooner rather than later, because you can put a whole list of issues on a board and it's really trying to figure out which ones to tackle first. That interconnection issue is one of the most critical. I think one of the other pieces that we've heard a lot has to do with just awareness, right? I mean, half of this is an education issue. Among those improvements that we've already put into place are training programs that we intend to roll out to all SDG&E employees, and not just our own employees, but contractors that are out there doing work on tribal lands. I think following protocols on when you walk onto tribal lands and figuring out what the appropriate level of permission is to be on that land. What it is, it's not just about digging, it is about even just accessing, whether it's federal land, Indian land, private owner land, Alati land. There's a lot of confusion, I think, especially with our contractors. So we've rolled out training programs. Michelle mentioned having dedicated folks that only work on tribal projects. We've done that. I appreciate the shout out from Larry that we're doing a good job, but we can do an even better job. And Jen Summers will talk a little bit about how she's reorganized our new business department. But one of the things that is really critical is having consistency of the folks that are working on tribal projects. It's super frustrating. You've heard it here today, to feel like you're making progress and then pick up the phone and have somebody completely different that has no idea what they're working on or how to address a project that's on tribal land. So a lot of improvement just on that piece of it. We already talked about here today the SLA process versus rights of way, so I won't get into a whole lot of detail there. One of the things I'm actually most excited about is just a more frequent conversation with the tribes on projects in flight. So we have already kicked off I'll show an example. It's sort of hard to see from here, but just a single piece of paper for each tribe that shows every interconnection, new project, new connection, and a column of, I think it actually says, the last status column is ball in court, and it literally just says, whose court is the ball in? Is it in SDG&E's court because it's still in design planning? Is it in the tribe's court because they've got to fill out an application? Is it in BIA's court because the easement request is being reviewed? And we get on a phone and on a call and we go through all of the open projects. This has been, it sounds very simple, but it has really impacted not just efficiencies, because half the time a specific project, it just might be an application hasn't been completed. That's, I think, just one small example of how we as a company can take that half an hour conversation and move things forward. Next slide. Oh, sorry, can you go back once? I'm stealing Jen's thunder. So some of you in the room, including Commissioner Haupt, when you were with us at the Tribal Leadership Energy Summit, heard specifically how management has taken a look internally at how we are organized, how our departments are organized. One of the things, and many of you know Jen Summers as our tribal liaison, and Vanessa's here too. Vanessa Vandiver is now our new tribal relations manager. Excuse me, I'm going to take a breath. Jen Summers has been moved into our director of our DPM, which is our new service role. Because of her expertise in tribal relations and land, she, from a management perspective, has been viewed as the perfect person to go into that department and reevaluate how we handle new business, how we look at interconnection, how we take projects and fix this timeline. It's not an overnight fix. It is, she'll show the timeline that Denise was talking about. It's not all consecutive, but we are making significant strides on how that gets addressed. She's got dedicated folks that are dealing with each of those steps. Vanessa and I are taking that piece of it and working together with each tribe. And so I think you'll see that that silo breaking down internally is one of the biggest successes that we feel like we've taken so far. So with that, I'm going to hand it over to Jen so she can walk through some of the specifics. And we'll all be available for the Q&A session. So thank you so much.
next slide, please. And thank you for the context and for holding this today, because I think what's very clear across all the sessions we've had highlights the complexity of what we're here to discuss today. And I do want to apologize to the tribal leaders and the tribal staff in the room today for the delays that we've had in our projects. I know the frustration and the hardship that these delays cause. And I do think, as Jen outlined and as Estella mentioned too, the work that we're doing today and just having the right people here talking about this is how we're going to be able to minimize delays that are caused by the number of processes and the people that are involved in a single project. So at SDG&E, we have roughly 18,000 projects a year. Right now, we have approximately 90 projects across the tribes that we serve. And these range from the simple, like we're using a service line agreement for a service line extension, our main panel upgrades, all the way to larger commercial developments and everything in between. And as has been mentioned today, we at the utility have a number of different departments that each play an important role. And as represented in this room, these are experts. These individuals know right-of-way better than anyone else. They know cultural resources. The team that I now have knows the design and project management piece. So they are experts in what they do. We have our own ball in court back and forth at the utility. And in addition to the teams that I already named, it also goes to our district office for inspections, and that's an important piece. It moves to construction for the actual meter sets and energization. And there are other parties too that are involved here that are not even mentioned. And then on the project side, with the tribe, we've got a customer who determines what their scope of work is, what if they want to put in, let's say it's an EV charger. And then you have the tribal government who is coordinating access onto the reservation. They're getting the tribal resolution together. As Denise mentioned earlier, you also at times have a general membership that needs to approve that as well. These are some of the parties. They've electricians, utility consultants at times are used in these projects. The Bureau for the review and approval of the right-of-way, if it's a right-of-way. And AMIHA was mentioned earlier today too. They help support a few of the tribes in our service territory as well, and also have the ball in court at times. So I just wanted to highlight this because in addition to the legality, and I really appreciated the context that was set earlier today, the legality of the rights themselves, just the number of parties involved in this is substantial. And this is where at SDG&E we're taking a hard look at where we can minimize these handoffs, where we can make our processes more efficient. Our systems, we use 20+ systems across one project lifecycle. We're going to work to reduce that so there's more transparency into where the project is within our own system, but then also share that publicly through our online portal so that a tribe or the Bureau even can look at that and see where a project is. So those are things that we have in flight today that we'll be working to implement to make these improvements. Next slide, please. This is the timeline slide, and Denise had shared some of this before. These timelines aren't unique to tribal projects. In general, this is our new service project from everything's going well to we've hit a couple snags and representative of the steps within the utility control. So there are also these other steps that I mentioned where we're getting input from the customer, review from the customer, we're getting easements and permits and other documents that we need to get from the external customer. Those aren't reflected here because they're dependent. It's dependent on the project. But this is just a high-level typical timeline, and this is what
we're working on to create the efficiencies on our own steps so that these timelines are reduced. I do think one of the things to point out here too is we do have, I know Yvonne did an excellent job outlining the BIA process. We have the bills survey, that survey piece too, that can add a lot of time to a right-of-way. That's already been flagged as a concern. I think that's a shared concern for us as well, just knowing that I mentioned just the 90 projects we have that are customer-driven projects, as well as fire hardening and other O&M projects that we have on tribal land as well, and that's just within SDG&E. I know BIA mentioned this. The bills surveyor is all of Southern California. So just wanted to point out that we have enjoyed a very productive and collaborative relationship with the BIA. We have spent a lot of time trying to figure out how we can minimize delays on our end on the survey side and getting our documents to the BIA as soon as we can. We've made improvements with our environmental pre-planning process so that we have more insight and can have those conversations with BIA ahead of time, what's coming, where we might need to make revisions to our right-of-way applications before we submit them for their review and approval. So we've been making the earnest improvements with the BIA, and now we're turning towards all the other improvements we can make across our own timelines for efficiency gains. Next slide, please. And this is one of the questions we were specifically asked to discuss, and it's when we need to acquire a right-of-way. I would add that in addition to all the context that was provided earlier today, we do also use service line agreements. That's how we extend off of a valid easement. So if we are connecting a home to a valid easement, we would use a service line agreement. If, as Denise pointed out earlier, we have, for example, a infrastructure that isn't covered by a valid easement, and we're trying to extend service off of that, then we do, as advised by BIA, seek a full right-of-way application for that to cover the distribution line and the service line that isn't covered by a valid easement. And then when we're upgrading our facilities, whether or not we have to submit a right-of-way application is also dependent on what our existing right-of-way is. So there are instances where maybe we have to expand infrastructure that's outside of our existing easement. When that is the instance, we have to amend that easement. We have to provide that right-of-way application to the BIA. Next slide, please. And this just drills down a little further our right-of-way application process and where it falls within our overall timeline. So as you see here, there are a lot of things that happen before we get to submitting our right-of-way application to the BIA. This is where our land team is getting information from our planning team to then go research and interpret existing rights, determine what we need to ask the tribe for, if it's going to be an easement or if we can use a service line agreement. They're conducting environmental review at this stage, putting it all together in the right-of-way application, maybe meeting with BIA for pre-planning, getting the survey, coordinating with tribe to get access to go out and survey, getting the survey, the legal and plats, packaging that up, submitting it to the BIA. That's just all the steps involved here in the easement. And then once we get approval, after the BIA has had a chance to review and approve that, that's when we can move a project into pre-construction and onto construction. So this is where we have seen, it's a longer process than projects that aren't on tribal land, and where the topic of today has been focused on. Next slide, please. And then the service level agreement process, which I know has been covered already in detail, and I won't rehash that, is coming within the same time in our timeline. It's just a shorter process because it doesn't go to the BIA for a full review and approval. It goes to BIA for recording. So I just want to thank everyone again for the time today to have this discussion, and for the CPUC and Rincon and everyone that's here today for being part of solutioning here. So thank you.
Thank you so much to our presenters from SDG&E. Now, all right, now I would like to invite Julio from AT&T to provide a presentation. Thank you.
Thank you, Amanda. Good afternoon, everyone, and everybody that's logged on online as well. Thank you for being here. My name is Julio Figueroa, and I serve as the tribal liaison for AT&T California and Nevada. I've been with AT&T maybe all the way up. Yeah. I'm just kidding, that's fine. No, that's fine. There we go. I'll speak loud. Now, this is not set to 6'7" Mexican height, so I'm gonna do my best. Anyway, so been with AT&T for it'll be 26 years in December, and I've been doing the tribal work for AT&T California and now Nevada for about 3 years. And so one of the things that I learned early on was learning the kind of rules of engagement of collaborating with tribes on their tribal land. It is not our typical business, right? And so we had to learn the intricacies of working on tribal lands. But we hadn't done that in the past, other than maybe deploying copper lines and landlines in the past. So the endeavor of providing fiber introduced a lot of challenges that AT&T wasn't used to. And one of them was, and we did this in this building, was accepting tribal law as part of our agreement and working with Indian country. We had never signed an MOU anywhere in the entire country where we accepted tribal law, and we did that here in Rincon. So that was a message to Indian country that we were serious about working with Indian country here in California. So I got to thank Rincon for that collaboration. It took a lot of time and work to get that MOU completed, but I think that kind of opened the door for AT&T and Indian country here in California about collaboration. I think that was mentioned earlier about trust and transparency, and through those tribal consultations, that's what comes out of those meetings is a mutual trust and a transparency of the work that's going to happen on their lands. If we can go to the next slide there, just a little bit about what I'm going to discuss, and I think a lot of it has already been mentioned. I'll go over some of the tribes that we're working with now. The right-of-way process, which I think Yvonne at VIA covered it, how we're tracking that, and of course some challenges and solutions that we've identified. We can go to the next slide. So currently right now, and I forgot to include another tribe on here, but we currently have a collaboration with 5 tribes up and down the state, one of them being here at Rincon. So we have a partnership set, so we're going to be delivering fiber to every location that has been identified by this tribe. All the tribes on here, including Pinoleville Pomo Nation, which is out of Ukiah, are all waiting for funding to fund these projects, with the exception of San Pascual. They have decided to self-fund to expedite the build-out of that project. They are also submitting grants to reimburse some of that money that is being spent on that. But for San Pascual, we've actually lived through this in the real world in regards to the application process with BIA and everything else that we have to deal with. So I think I can agree with the rest of my industry partners is we do want to connect our folks as fast as possible. If it were up to us, we would have fiber on all these tribal lands last year, even 2 years ago when these talks started. But those are not the rules that are in place, and we play by those rules, and so we have to go through the BIA application. With San San Pascual, we signed the contract last year. We are still in the process. We do not have shovel in the ground. We do not have fiber on the reservation because of how lengthy that process is, and that is the BIA application does require NEPA, and I think you have my sentiments, Pilar. You mentioned about NEPA. I wish we wouldn't have to do NEPA. That takes about 10 to 12 months as part of this application. Legal plats, legal descriptions and plat maps, doing the survey on that takes almost 6 months, and that's again required through the BIA application. So CPUC, if you have any influence on changing the Code of Federal Regulations on the BIA application, we would be more than happy to see anything that would expedite the process of deploying that. But I would say, to the BIA's credit, Yvonne and her team have been responsive. When our teams are checking in with them on it was said earlier, ball in court, Yvonne and her team respond quickly to us. So I appreciate that. I think Jennifer mentioned it. Bills, the Bureau of Land Management, they're taking 90 days before they even open up an application. So I think Yvonne's doing everything that she can to talk to them and say, can you guys please prioritize and expedite that? Because waiting 3 months before even it being looked at, it's just adding more delays for the tribe wanting to get fiber on their land. So again, these are the tribes we're working with, and when we do collaborate with these tribes, it's not just a business transaction. We do sit down and we have a consultation meeting. We want to find out what exactly is that they want from AT&T. What do they want on their tribal lands? Is it fiber? I mean, is there a wireless need? Because when we place a cell site on a tribal land, we have to go through the same process. We have to get a right-of-way, an easement. We have to get approval through BIA, and so we're hoping that that process also is expedited. But it's not different if it's fiber or if it's a cell site. We still have to go through that same process, and it's lengthy. But it does start with a consultation meeting, sitting down with the tribal leaders or their department heads, finding out what their need is, and then seeing if AT&T can deliver on those needs. Once we have that in place, we do go into a non-disclosure agreement, because there is an exchange of information that is proprietary to both entities. The tribe is now giving us all of the locations on their reservation. That stuff gets out, all of a sudden these tribal citizens and members on their land are starting to get marketing material that they shouldn't be getting. So we protect that information, and as well as once we provide our cost estimate to the tribal lands based on all those locations they've given us, that estimate is proprietary to AT&T, but it gives them at least an idea of what it would cost to bring fiber to all those locations on their tribal land. And if it does suffice and they want to move forward with it, we can decide on a contract or an agreement to bring fiber to those locations. We did that at San Pascual. They decided to self-fund it, and then we believe that our estimate is pretty close to what we gave them in our initial discussion. So we're confident with that. If the tribe decides, hey, listen, thank you for the estimate, we're going to go our own route, and that's okay as well. It is not binding. If the tribe decides, hey, let's go ahead and just be our own internet provider, we applaud them. We will help them in any way we can. If they decide to use us to connect their reservation, and then from there the tribe will run their own ISP, we applaud them. We will partner with that. We're doing that now. So if any tribe out there wants to be their own internet provider on their land, I would ask you to call Tule River. They're doing that right now in our service area. We bring the fiber to the board of the reservation, and from then on, they take it over. We do provide services to about 48 of the 109 tribes in California. So of those 48 tribes, whether they want to collaborate with us or not, those consultation meetings would result in the end, a result of whatever the tribe wants to do. So these are the tribes we're working with, and again, from a CPUC perspective, I would say how you can help in expediting this is if there's an FFA grant, which I believe Barona has, and I think Pinoleville has, is just make a decision if you're going to approve that grant or not, because I think the tribe would want to know if it's a no, what are the next steps, and if it's a yes, let's start working on the processes with the contract and design engineering and so forth. Same thing with NTI, and I know they're not here, but I'm sure that the tribes would like to also be notified if their NTI grant would be awarded, so they can also decide what are the next steps. The next slide is our right-of-way processing. We follow, again, the checklist. I won't go into detail because I think Yvonne provided that as well, but we do have to follow this. Again, we cannot put a shovel in the ground or a fiber on a pole until we've been given the approval from BIA, and we follow the current application now. Next slide. So I will give the example, as at least for San Pascual, because that's where we're at right now, is waiting for the application from BIA. We are currently doing the plat maps and legal descriptions, and I believe Bills is looking at that right now on the survey. So we are checking in with Yvonne, I think, every 2 weeks on the status of that. She's been very responsive. We also provide a bi-weekly update to the tribe to let them know where we're at. If there's something that we've identified that is internal to the tribe, we let them know, hey, we're waiting for a response from your cultural department, and so they can also nudge their folks internally to expedite that. And so the lines of communication are open with the San Pascual tribe, and so we can just either call each other, send a quick message, and we will notify if it's our folks that have the ball in court, or if it's their folks, or if it's BIA. We have an open communication to get that ball moving. And of course, our right-of-way folks are in communication with Yvonne and the BIA. Next slide. Challenge and solutions. Again, I think we've heard it today. Is kind of the timelines and what we're required to do throughout the BIA application. Environmental, the NEPA, I shared with you, it's about 10 months for us to get a NEPA done for San Pascual, and we expect that's how long it's going to take to do Rincon and the other tribes as well. For us, I think a solution. I think we've learned through this process on how to get stuff done quicker, working with San Pascual and Rincon. So thank you both tribes for giving us that knowledge of getting that process done as fast as possible and being more efficient. And then I think that was also mentioned earlier, is just working with the power companies when we're going to be deploying our infrastructure on their own poles. And so we have a process in place that does that now, but as they have plans to underground their facility, it's putting some difficult decisions on our end of where we're going to place that fiber if that pole disappears. So again, that's working with the tribe and with SDG, at least down here, to identify the best solution. But with that, that is my presentation. I do want to acknowledge a couple of my colleagues that are here today. Rachel Lewis, if you want to raise your hand, she's the area manager in network, and she oversees the team that does right-of-way. And then Nemesis Wynn, she's our FirstNet consultant, and so she's the one that assists all the tribes down here in San Diego should they want to adopt to FirstNet, which is the mobile broadband network for public safety and first responders. And with that, thank you.
Thanks, Julio. All right, and now we're going to go to an online presenter, Ted Gilliam with Zayo. Ted, are you online?
I am, Amanda. Can you hear me?
Yes, we can. Go ahead.
All right, great. First of all, thank you for the invitation and opportunity. We're excited to talk about what Zayo is doing across the nation, and more importantly for this group, what we're doing in California. When we first talked, Amanda, I thought you were going to have to suffer through listening to me present this entire presentation, but I found an expert. So with me is Mark Allen, who is a program manager with Zayo and gives these presentations regularly throughout the country. So I'd like to turn it over to Mark if I can.
Do we need to make Mark a panelist? Okay, great. It looks like we're doing that, so you should be able to turn it over to him.
See a picture, so maybe that worked.
Great. Can everyone hear me all right?
Yes, we can hear you.
Great. Thank you. Thank you, Ted. And again, want to thank the CPUC and BIA for inviting Zayo to speak today. My name is Mark Allen, and I'm a program manager of the government stimulus team at Zayo. and we're responsible for the federal, state, and local grants in support of bringing affordable, equitable, and reliable broadband for all. I also work with local internet carriers to ensure they have the resources and expertise available to deploy broadband networks in their communities. Many of those communities, as we know, have been historically underserved from a broadband perspective, and that is one of the things that I spend most of my day job thinking about. And I believe we have a slide deck. If you could move to the second slide. And one more, please. Oh, I realized my face was covered up. So first, I'll begin with a brief introduction of Zayo. Zayo is a private fiber owner and operator in North America with a significant footprint in California and Southern California. We are often referred to as the carrier of carriers, meaning we manage and operate the critical infrastructure for fiber optic internet that supports many of the last mile of fiber to the home or internet service providers in California. In other words, Zayo provides core services to ensure local internet providers have access to the broader nationwide set of critical data centers and internet infrastructure. One thing I tell my friends and family is many of the internet providers, for example, AT&T, who spoke earlier today, those more household names, in many places they're interconnecting with Zayo to carry their connection throughout the nation. Next slide, please. So within California, Zayo was awarded an NTI Middle Mile Fund, or sorry, Middle Mile Grant. And as part of that grant, we began to develop internally a new kind of architecture. And that architecture really highlights the need for not only building a project from point A to point B, or from data center to data center, or metro area to metro area, but instead creating more of a highway system. And so again, the way that I talk about it with many of my friends and family is historically a lot of the larger carriers like Zayo were building toll lanes essentially between geographic areas. And now with the support of the NTI Middle Mile grants and other local municipality grants, Zayo is really developing more of a highway system. And the intent of the highway system is to offer exit and on ramps to our network. And I think that's crucial so that these communities adjacent to our larger projects that we build across the states have the ability to interconnect and benefit from that internet connectivity that otherwise have just been going down the road past their house. I used to be on numerous teams at Zayo, and I would get calls quite often saying, "Hey, Mark, we're getting a call, or sorry, we're seeing construction done outside of our neighborhood. Is there any way we could access that fiber network?" And again, historically, the answer had been no, because there wasn't a technical solution or the funding to provide that. But with this digital equity access network, we're actually providing that local service as well as that connection between large metro areas. And next slide, please. So within California, Zayo continues to organically expand our fiber footprint and is always seeking local partnerships to continue the development of middle mile broadband networks. I'm sure many of you are looking at this map, it might be a little small from your perspective, but you're wondering, well, there is not a project area right now in Southern California funded by the NTIA. And one thing that we'd like to do is really model and leverage the lessons learned from that program to develop more of these projects within the region of Southern California. And before I hand it off to my colleague Ted, I again want to highlight that Zayo views ourselves as an enabler of local internet service providers, municipalities, and tribal nations in their effort to provide affordable, equitable, and reliable internet service in their communities. And thank you. I'll hand it off to Ted now.
Thanks, Mark. Next slide, please. Thank you. So I know this says tribal land policy, but we don't really have a policy and we really don't have a strategy. We think of it more as a relationship approach. We have a very strong code of business ethics and conduct that applies to all ZAO employees and all third parties that we deal with, including tribes. Some of the three main bullet points of that code of business ethics and conduct is that we respect everyone, we deal honestly, we earn trust, and we own outcomes. As you could see from our map of the long haul routes that we have across the nation, we do come across tribal land frequently. And as part of that, the first thing that we do is we reach out to the tribe and their right-of-way management office. And we ask them, okay, are you willing to let us traverse tribal land? And if so, under what conditions? And then we have a discussion about it. Are there any communication needs that the tribe would find useful? And from there, we develop a contract and we do the right-of-way application. We do the NEPA and the CEQA process, including inadvertent discovery processes. But we're always mindful that, you know, it's not just the tribal land that is important, it's the ancestral land. And when we go out and we do these construction projects, we look at that. And that's our relationship approach with tribal leaders. So that's all for ZAO. I know that we're out of time, and appreciate the opportunity to tell you what ZAO is doing in California. And thank you.
I'm on the portal and I see that, and then it's like, oh, SDG&E dropped their application. Now I got to go resubmit. And so if you're stuck in that loop, and then that adds to your 40 to 72 weeks to get the electricity turned on, right? And then also there's a lot of emails that I have had with Jennifer Summers in the very beginning. So I've been sitting for about 4 years now. on council. And so it's like the terminology of the service line agreements and the right-of-ways have consistently been confused and muddled at different levels of service with SDG&E. And for example, it's costed our tribe just for 2023 to 2024, $393,000 because we have been having to function off of generator rentals and fuel. And so, so when I calculate that up, you know, for at least the 22 months, that's like $17,898 a month, just on fuel and generator rentals. But then that also doesn't add into about maybe 5 homes being without electricity that are brand new, built, and they're in our community, and the people are salivating to move in. Because if you're in crammed housing or you're homeless and you know you have access to a brand new home, but you can't move in it because there's no electricity, and then propane won't allow delivery and hookup without electricity, and things like that. And so it's just like the backup is just chaotic for us. And you know, I just recently built a house over in Valley Center and didn't have any problems with electricity, and I was anticipating not to move into my new construction home and for like 1 or 2 years, but to my surprise, it just was streamlined. And so I scratched my head, and it's like the service line agreements don't need BIA approval. So I don't understand why the new homes can't be turned on right away. And then it's just, I'm glad this meeting is happening. You know, and I'm glad that you guys are, you know, developing your infrastructure and you guys are trying to streamline things. And, you know, I do appreciate the 3 principles of transparency, stewardship, and collaboration, because I really do feel that with Jennifer Summers and Vanessa, as we've been working with them the most. But I think to even strengthen that better would be some type of tutorial to access your portals for the people that are on our side that are streamlining, helping to streamline those applications. And then also maybe a to-dos list for the project managers on your side of giving us those spreadsheets of projects that are scheduled to be, you know, like turned on at different levels or what needs to be done. And then also doing some education with your contractors that come out to tribal lands, especially because of the hardening projects that you're doing. A lot of them want to go through really divided fee land lots, and we're like, no, just go this way, and we can give you a resolution tomorrow. But they're like, no, we need to go through this way. And so they're not listening to us, and we're the experts on our own land when it comes to jurisdiction and, you know, guiding people through the process of a simple tribal assignment versus a subdivided interest fee lot that, you know, takes time. And so, you know, so I'm just happy that, you know, this meeting has happened today, and that would be La Jolla's request, is the tutorial for the portal site.
Yeah, thank you, Chairwoman. I appreciate that. And the portal is meant to be that, right? Transparent and make things easier. So the fact that it's not is a problem. So I've never gotten into the portal myself. So when I get back, I'm going to have Vanessa walk me through it, because I should see for myself how not easy it is, if it's not easy. Part of our training is, Vanessa and I actually just talked about it a week or so ago, about the portal itself being part of the problem, and we need to fix that. So I hear you, and we will work on fixing that itself. It is also confusing even internally for us because we have multiple numbers associated with each project. We have land that has a number, right, Estella, that has an environmental number. There's a different new service engineering and design number. So even internally, we've got to clean up the project references because it gets confusing. So we're working on that as well. And actually, we're meeting tomorrow, so I look forward to that. We have that list that I showed as an example that we will be bringing to you. So the spreadsheet that we have that goes through every single project, you will have that, and we'll set up ongoing meetings where we can walk through the status of each of those. So I'm glad we're having these conversations today, and we are taking notes about your specific request, and we'll go through each of those. So I appreciate it. Thank you for that, and thank you for the continued patience.
Hi, good afternoon. My name is John Flores. I'm the environmental director for the San Pasqual Band of Indians. So I just want to talk about our experience too with SDG&E because we're in SDG&E territory. I've been lucky enough to be with the tribe now with San Pasqual for 13 years. So in my feelings working with the tribe, there is before COVID experience with SDG&E, right-of-ways, SLAs, and after COVID. And before COVID seemed to be good. We would get SLAs done in a timely manner. We would get right-of-ways done in a timely manner. And then COVID came along, and everything is taking a year plus now. I know some of that's due to staff turnover and retention. Obviously, some people decided to retire, and you need to replace those. But I feel like you need to hire more planners for our service area. To get a planner out to the reservation can take up to 6 weeks long. So that's almost 2 months of a home just sitting there. Then you have to go back and do your internal load calcs and documentations, and they get the papers, delivered to us for an SLA, and then we need to get it signed. A brand new home for a single line agreement, in my opinion, should be no more than 3 months long to execute to get that home energized. So if there's any way we can staff up with SDG&E and get more planners, I think that would be helpful. In terms of right-of-ways, I think it would be really great if there was a way the BIA and the utilities could accept tribal, TIPO, cultural documents, and tribal environmental documents for NEPA compliance. If our tribal staff and government has the ability to produce what we feel are, good cultural documents, good from our TIPOs, environmental reports, then you should accept that rather than going out to an outside service like DUDEC or someone like that to do that work. And maybe that will help speed things along. I think it's great that SDG&E and all the utilities now are doing undergrounding throughout the reservations to help with PSPS events, public safety shutoffs. Going through that process lately, we've also learned there's a lot of lines on our reservation that don't have proper right-of-ways, and now we're going back and doing the work that's been done. And also we noticed there's a lot of documents where there's a right-of-way for just electrical service, but not telecommunication service that's been on our reservation for decades, illegally trespassing. So a lot of our right-of-ways that we do have are silent on AT&T or whatever telecom company has been hanging on underneath. And I feel like BIA and no one comes to us as a tribe to help us get made whole for what was done illegally. Because I'm guessing SDG&E has been collecting a service pole fee of some sort from a telecom to rent space on their poles and are making money off of that. But the tribe is not getting compensated for that for decades. And then what's turning around and happening now is SDG&E is quit claiming their above ground poles to the telecoms to take over. And there's really nothing going on there, I think, between the telecoms going back what they're going to do to maintain those poles with the tribe to get the proper right-of-ways. And there's been plenty of times where the tribe has asked the telecoms to go co-locate it underground into a trench with SDG&E. Because when they hear SDG&E is undergrounding, a lot of tribal members and tribal government people believe that our line of sight view of those poles are completely going away. And I have to tell them that's not what's happening. SDG&E is going to cut the top 10 feet off of that pole off and leave that bottom line there. And all we're going to get is maybe a secondary steel pole next to a wooden pole that's about to fall down, or they're going into a trench. So these are some of my issues. I have a paper that I keep of, issues we have with utilities going forward on the reservation. So yeah, that's just some of our grievances that we have with what's going on right now. And I feel a lot of times the tribe is in the middle of two parents that are bickering in a divorce of the utility and the BIA, and we're the children stuck in the middle that aren't getting the attention that we need or the resources we need to go forward to complete, whether they're large microgrid projects or small individual house projects. For me, as the environmental director who works on multiple projects, both small scale with a tribal member getting a home to a microgrid project for a government center, they're the same in my eyes. The one that's actually more difficult is the individual tribal member, because that's one paying a mortgage on a home that they can't get into. My government project is important to me, but that tribal member is calling my chairperson complaining, saying that we as the tribal government, me and my staff, are dropping the ball on a system that we have no control over. And all I can do is email and email and email, but to the person that's trying to get in their house that might be paying 2 mortgages or a mortgage and a rent off reservation, every month is more money that they're paying out of pocket. And that's all I got for now. So, but thank you. I do appreciate these sessions. They're helpful. And it's not just homes, microgrids, but also I do the water for our reservation. So when I'm putting out water pumps to push water to a new development on the reservation, I need power to pump so I can move water. So energy, in California, we spend almost as much, money to move water around as we do to buy water, to push it up and down these hills that you see here. So I think also when it comes to, I'm having issues getting water pumps, booster stations, lift stations energized so I can serve people water in their homes. So thank you for listening to what I had to say today. I really appreciate this. I know we will get through this together. We just got to figure out a good way to go about that. Thank you.
Yeah, I appreciate the comments. I'll give the utility a chance to comment if they want, and if Judge Colbert wants to add anything. If there's ways the PUC can help find solutions, I think the utilities are obviously the first place to go and work directly with them. But if you need to contact us for any reason as well, I think Judge Colbert is able to provide a couple of comments. But again, appreciate the feedback.
Good afternoon. My name is Anthony Colbert. I'm an assistant chief judge at the Public Utilities Commission. Part of my portfolio is overseeing our tribal consultation and land transfer policies, and also our investigation. So, as you all know, the CPUC regulates SDG&E, the IOUs. If at some point a tribe or an individual is having issues with getting rights of way, undergrounding, pole safety, you can file a complaint with the commission. You can make an inquiry with us, and we'll look into it. You all may recall from several years ago the town of Paradise, which burned because of all the fires. After the fire, PG&E was undergrounding their infrastructure for obvious reasons, but the cable company provider and the telephone provider were not willing to do that. The town of Paradise filed a complaint with the commission, and at the end of the day, the cable provider and the telecommunications provider put their infrastructure in the ground too. So the commission, that's part of the commission's job to do that. Thank you.
So I just wanted to say that if situations come to that, we have that ability, but we want to avoid that. And I think there's lots of easy, hopefully things that get us to the results you want well before we get to that point. And I think SDG also wanted to respond.
Yeah, thank you. And I appreciate, I'd love to meet up after this because I know we don't have time to go through the entire list that you you have, but I do appreciate you sharing. And you're not the first to bring up the sort of co-location issue with the telecoms, and it's something we've struggled with. And so first, I just want to say that as of last year, we formalized a policy now where, well, I'll back up a minute because as Judge Colbert mentioned, we are governed by the PUC, and there's actually a rule that says we can't say no when one of the telecommunication companies comes and asks to co-locate on our poles. So we do enter into an agreement. We actually don't make a ton of money off of the telecoms. I mean, it's literally like a couple $1,000s a year, so it's not a moneymaker for us, and we actually don't, it's oversimplifying it to describe it this way, but we don't have the ability to say no. But that being said, we've now formalized the process where we say, okay, before we allow you to do that, you need to prove to us that you've gone to the tribes and you've gotten a legitimate, valid right-of-way. Because I don't know historically, and most of us in the room that are sitting here representing the various utilities, we're not in the same seats that we are now. So whether it was 10 years ago, 20 years ago, if they didn't have valid rights of ways, that's probably nobody in this room's fault, but we don't want to be in that position to say, no, they don't have a valid right of way. It's now something we require. You can't attach to our poles unless you show us you have that legal right of way, that the tribes have granted you permission to be on tribal land. So hopefully that alleviates some of the future issues. It doesn't fix the past bad practice, but going forward, hopefully that helps. And again, happy to have a conversation after this too.
And just on that issue of the cultural and environmental reviews, that is an area where I think we can probably work together offline. There are opportunities, we think, to make sure that the scope of whatever SDG&E work needs to be done is included in a potential environmental review or cultural review that the tribe is doing. So that is definitely an opportunity that I think we're interested in pursuing, and in some cases have been able to. So let's discuss that one as well.
Let me ask the BIA this question, speaking of NEPA. So NEPA was just amended, the law. The regulations were also just amended. One of the major changes was, in fact, this point, that the federal agency is now authorized to use tribal environmental documents as part of their NEPA review process. I have yet to see the BIA do that, but it is now part of the regulations to allow for that. In addition, NEPA, the amendment authorizes the federal agency to use project proponent documents. So to the extent that there's no repeat of what has to be surveyed, it would be helpful to understand how the BIA will be incorporating those NEPA changes into their review process for right-of-ways, or anything else for that matter, but since we're talking about right-of-ways. So, John, your stuff should be being used by them now, so that they don't have to go out and get another third party to do the work, whether the utilities have done the work or whether the tribe has done the work. Now the NEPA regulations and the new NEPA amendments give the agency the ability to use your work and not go out and do it again. So it would be helpful to understand if the BI is already changed or starting to change. I know your NEPA guidance book is 15 years old or something like that, and got to be done by DC. I understand that. But it would be nice to see some of those efficiencies implemented quickly. So it might be helpful if maybe the BI had some thoughts on how those kinds of NEPA efficiencies could happen. Let me, on the second point about we have to hang telecom on our poles. So this will go back to the point that I made, and I'm not going to belabor it, but I would like to respectfully request that the tribes get some guidance from the CPUC on how we can and should engage you to change your orders to accommodate tribal easements and the treatment of tribal easements and BIA easements differently for purposes of your access rule. Because the Federal Pole Attachment Act allows the state to preempt the feds, which you've done at the CPUC. But of course, the tribes would argue your stuff doesn't apply, even though you regulate the utilities. And what's happened is now telecoms are in blatant trespass on Indian lands because they have not received tribal approval or BIA approval. Remember, it's not the tribe's easement, it's the BIA's easement. So, if there's an opportunity to sit down with the CPUC, whether it's in consultation or otherwise, or even in formal action, as you're going through your orders, to create a tribal exception or a separate tribal rule for the non-discrimination, we get to hang telephone poles or broadband or whatever it might be. Could be cable TV, could be, you know, cell towers. It can be any kind of telecom that's covered. And while SDG&E has a rule, I don't know that SCE has a rule. I don't know that PG&E has a rule to seek tribal approval. But that should be a CPUC requirement, not a utility by utility accommodation. So if there's a way we can have a discussion about how we formally work through the CPUC to amend your orders to treat tribal lands differently for purposes of hanging stuff on poles without tribal approval, that would probably be the better way to have a uniform approach across 109 tribes. Those are my 2 comments. Thanks.
So I'm going to respond for regarding the NEPA document. So at our Southern California agency, we are in the process of implementing using existing studies, environmental studies, biological, cultural studies, to do our review. We see the value of the amount of time that the review is required, and also amount of resources that needs to go into do another study. If the conditions, the existing conditions are the same, we're happy to use whatever the culture, the tribes is providing. You know, like if John says, hey, we just did this study last year. So sure, we'll take that. For biological or cultural, we don't have agency specialists or subject matter experts, so those would go to the region. And it depends on the subject matter expert for them to review the biological and cultural. And obviously, if the area has been studied by the cultural, nothing new should pop up. And for biological, I believe they do have to be reviewed more frequently than it would have been for environmental. So yeah, we like to use whatever's existing, and you know, it just saves saves everybody's a lot of time and a lot of resources to redo them.
The Bureau of Indian Affairs has, for at least a couple of years, been utilizing tribal documents environmentally, culturally. Some of our tribes here are TIPO, and we have a new archaeologist, which we're trying to transitioner into being more proactive with our tribes when it comes to the archaeological, the cultural part of that. But we have been doing that. And I guess maybe an obstacle there is perhaps a disagreement on what may be stale, biologically specifically. And again, we have a new individual at the regional office. Unfortunately, the agency doesn't have the benefit of those subject matter experts, and we do have to go to our regional office. And I'm sure everybody does know that we utilize what we call the NEPA tracker. So when Real Estate Services, for example, receives an application, part of that application, it has to be complete, number one, but part of that is the environmental portion, which is uploaded into the NEPA tracker, where the individuals who manage that tracker assign it to the subject matter experts. Now, any document that the tribe provides is uploaded into the NEPA tracker. So it's pretty well like a well-oiled machine, at least for Southern Cal. So I hope that helps a little bit.
Yeah, I just had a comment from what Pilar shared. That should be comments and recommendations, not Q&A discussion.
And I'm taking notes. We are going to follow up on all the recommendations we're hearing.
All right, thank you. So I was just looking at your website for the California Public Commission's website, and there's tribal nations are invisible on your website. So maybe if there could be a section on your website on how to work with tribal governments and engage, because as we progress and evolve here and technology advances, there's going to be more utility providers, ISP providers coming through, and they're going to need direction. And so it would be nice if we really did show a partnership in working together. And so that we're visible on your radar, you guys are invisible on our radar. Yes, of course, we want to be safe. We want the best equipment on our poles. We want to do our part in eliminating wildfires from happening on our tribal lands. If we can do more hardening projects with, utilities and things like that. But we have to be visible to each other. And so I think that would be a good step forward for us to be visible on your website.
I absolutely agree. We do have an Office of the Tribal Advisor. That position is currently vacant, and we're in the process of bringing somebody else on, but our website is not easy to maneuver. The information is not easy to find, and tribes definitely do need to be more visible, and the information that we provide needs to be, I think, like you were commenting to SDG&E, it needs to be useful, and we need to be highlighting the work and partnerships that we're doing and making sure that we're listening to you about what information you need and making that accessible and having a user-friendly website. So I absolutely agree with you, and that is something I am highlighting in bold on my list here.
Hi, I just wanted to follow up on the comment by the BIA. I'm sorry, I forgot your name. But that does not apply, of course, to the plat and GIS files that are required. I know that that's a very separate matter, and there's no sharing of for example, with SDG&E and AT&T in their co-location efforts to just use one set of plat and GIS files rather than have to recreate them every time. I know that I spoke with Yvonne about this, I believe. She's here. As part of the row process, there's a need for the plat and GIS files that will be created in coordination with the NEPA process and the row requirements. And for that, when needing to create those documents, for example, SDG&E is doing the same kind of work as AT&T will have to do in relation to its utilities, undergrounding, and then AT&T will, to some extent, have similar a similar direction because to the extent there's co-location. So why do we have to do two essential surveys for what is very close to being the same project?
There isn't any reason why you couldn't use the same map.
It's not a map.
If you're using a survey, the survey, by our definition, the map of definite location, if the information you have, whether it was done by AT&T, SDG&E, or your own private certified surveyor, it's irrelevant who does the survey as long as it is verifiable and it describes the right-of-way as is required by 169. So it doesn't have to be done by AT&T and SDG&E and the tribe and whomever else. The same mapping data can be used as long as it meets the requirements.
Thank you. That is new information. We were told otherwise.
I really appreciate this convening today, this workshop on this topic. My name is Josh Simmons with Prosper Sustainably. I'm in a fairly unique position. I'm owner's representative for several tribes throughout Southern California, Rincon, Pala, San Pasqual, Verona, Morongo, on energy projects and, kind of at the front line of the rights of way and other kind of related issues that are preventing the projects from progressing to substantial completion in PTO. And I'm also co-director of the Tribal Energy and Climate Collaborative. That's a program under the Southern California Tribal Chairmen's Association. And really the whole goal of that is to prevent these from being one-offs. So I work with a lot of tribes on these projects, and I get a lot of different responses in terms of timeframes, in terms of process, in terms of barriers. We see, a number of planners sometimes. We see just one tribe's told one thing, another tribe's told another thing. Through the Tribal Energy and Climate Collaborative, we're hoping in our work with tribes on these projects and being able to work with people like Denise that and broader teams that we have that in each tribe has their own their expertise, solutions like to systematize this. So we're not having one-offs. How do we open up this black box? So the slide Denise showed up there in terms of the process as we understood it of the rights of way was just due to a conversation we had with SDG&E about a week and a half ago where we talked with the planner, land department and others and asked them specifically what are the steps of this process sequentially and how much time are each of them going to take. And the information Denise had up there was what we were told during that meeting, which differed slightly from what Jennifer was told or just showed up on the screen. So I think at the end of the day, really the success we should hopefully be working toward is how do we make this process clear for everybody? How do we make it so that, the tribes that do have more expertise and resources to dedicate to this and are able to bring those resources to bear and be at the table aren't the only ones who are able to progress in these projects. So through the Tribal Energy and Climate Collaborative that in the tribes that I'm working with, I can also support tribes like Los Coyotes, who's had a number of homes who have been without being able to connect them for years. And that process is clear, consistent, and it's being made as efficient as possible. And so hopefully if that process is clear, then there can be more resources dedicated to it. And so through tech, we're looking to ensure that we have kind of broader representation for all the tribes in the region, and hopefully that benefits tribes statewide as well. So, I would, encourage those from SDG&E, Southern California Edison, BIA, and others also to reach out to me. Not just a representation of the tribes we're working with directly, but also for the collaborative. And we have attorneys, engineers, and others that were and the expertise of all these tribes and the experiences they've had, the successes and the failures, to hopefully let's make this clear for everybody. Let's get everybody on the same page, and let's make these projects faster and more successful. So I do appreciate Commissioner Hauk in particular in leading some of these efforts and highlighting and elevating this conversation as well. So just kind of throwing it out there. So I appreciate everybody being here today.
That services 3 homes, and we're just grateful that you're assisting. I wish we had the staff that, you know, to actually work with them individually.
That's all Jacob. I just know about it because he's told me about it. We're doing what we can to support Los Coyotes, but I think Jacob's the one who's been working at that for a very long time. So hopefully that credit goes to him.
Yeah, I just want to respond to that because we've also been working with Jacob and Los Coyotes and going project by project on how to get those homes hooked up much faster. And as far as Jen Summers goes, just this morning, and I have it in front of me because your point about the timeline is a good one. She didn't get into too much detail today because of, you know, sort of time constraints, but just this morning, in an ongoing collaboration with the BIA, and she will be sharing this with each tribe, but to the earlier point of having a dedicated resource for each tribe, she's got 4 planners that are very specifically dedicated based on regions to each tribe. So there is a very specific timeline that has been revised, updated, improved, that is now showing the specific timeline and the planner that has been assigned to each tribe. So that is just one example. And so we'll be sharing that more broadly with each tribe. Each tribe will get a copy of that timeline, the phone number, name, contact information for the planner that they can reach out to and have one point of contact. So hopefully that helps.
And just on the processes not lining up and being a little bit inconsistent, if you went around and asked each of our internal silos what their process is, it may not capture the opportunities that we're looking for aggressively to overlap so that those processes don't have to run in a linear fashion. So as I stated earlier, we are a continuous learning organization, and one of the things that we're constantly doing is try to find opportunities to streamline. The point earlier about relying on other environmental documents, that will help us tighten up and maybe reorder how the sequence works. So it doesn't help with the frustration associated with confusion around what is the time frame if the time frames are constantly moving. But I think where we can probably do some more work on the portal or otherwise in our tribal communications is updating you on how the process is shifting for the purpose of streamlining it. So hopefully that will help with the transparency that we're trying to achieve here, make the process shorter and make it clear to our customers.
Hold on for just a second.
But I'm not quite sure that when we're receiving those documents with an application that we're seeing any tribal documents submitted. So that's kind of been an issue because if we're looking at a development on a tribe and an EA's been done, you know, last year, we want to see it, you know. I'm not sure SDG&E is pulling that in as well because that in itself would streamline.
Good afternoon. My name is Susan Recker. I'm with the Ramona Banakuia. And
so that people online
okay, sorry. Anyway, So I was saying, my name is Susan Rucker. I'm the tribal administrator for the Ramona Banaquia. And today I am here seeking assistance from the multiple entities and agencies that are here addressing right-of-ways as well as providing utilities. The Ramona Banaquia is 100% off-grid. We have no power on the reservation. We operate 100% off of hybrid solar through solar generators. And we have a situation that we're working with the ANZA co-op, who's indicated they have no jurisdiction over an off non-Indian fee land that has the only possible transmission that we can connect to. So the request for assistance is who here can help us try to get an easement by necessity from a non-Indian reservation fee land to bring power to the tribal reservation.
Oh,
Up.
so just to clarify, the non-trust land, the fee land, that's held or
Privately owned.
Oh, I'm sorry, can you repeat that?
It's privately owned.
It's privately owned, and it's not owned by the tribe or a tribal member.
That is correct.
If it's within ANZA's co-op, the PUC does not have jurisdiction over that, but we can, I think, talk to you to look at the maps to at least identify who would have jurisdiction on.
Well, I have spoken with the CPUC at several other workshops, and they have identified that the reservation is not on the map as Edison. ANZA co-op purchase, they're privately owned, the co-op is, and they provide the power to the ANZA community. Unfortunately, the closest transmission sits about a half a mile from the reservation. And as I said, it's a fee land, but basically the owner is holding us hostage, who's only willing to provide access to the co-op in lieu of the tribe providing some other concessions. Concessions that we cannot comply with. And our current situation is not right away through the BIA from the reservation or throughout the reservation, but how do we bring that power from fee land to the reservation? What agency or entity can we work with who would be able to help us bring power to the reservation? The cost for, solar hybrid systems could go anywhere near $100,000 to $150,000 to operate just one home. So it makes it very difficult for the tribe itself to create any kind of economic development on the reservation, seek self-determination or become self-sustainable if we don't have power. So resources are very limited to the tribe when it comes to grants. And so we usually max out because of the cost to add, power to new housing construction or any kind of development because we have to power. So this is a serious situation, especially during COVID, and you're dependent on the only power source that you have, and that's through solar.
So I'm happy to talk about that more either later this afternoon when we're in the government section, and also put James on the spot that maybe Commissioner Gallardo and I could meet with the tribe and at least help sort through who it is, that would have authority to look at this issue and work with the tribe to see how to get energy there to you and just understand the issue a little better. But it sounds like it's all within the co-op area that the PUC wouldn't specifically have jurisdiction on the.
Richard.
Is this on? Yes. I'm James Spence. I'm a acquisition manager for Southern California Edison. And we run into this problem on occasion with private parties where we have to connect someone, but there's an interim property interest. So we would have to negotiate a right through that property. So it sounds like this is a similar situation. This is a fee connection. It's not on the tribe. And there's a party in between to get access. But we can take a look at it. So I will give you my contact.
That would be great.
You can certainly reach out to me, and then you can also talk to the CPUC on any ideas they have or resolutions they can help with.
I think that sounds, that would be great. I think that would be helpful if you could talk with the tribe, and then my office will work with James to see if we can follow up as well.
Thank you. I'm Tijuana Cervantes, and I serve as the Executive Director of the California Tribal Solar for All Consortium. And I'd like to make a recommendation that's kind of old-fashioned and preface it with something from my home community in Savannah, Georgia. For 161 years, my community has met faithfully every December 31st to celebrate the Emancipation Proclamation. And to my knowledge, that history has never been broken in my community. Because my community decided that this information was important enough that every year we would reiterate it, we would talk about it, celebrate it in different ways. And one of the thing I want to recommend, because what was brought to mind is how a number of you have cited that in your organizations, institutional knowledge is lost because people are retiring or people have moved on, all types of attrition. And I want to recommend like having some type of wisdom circle in your organization where if you know someone's been there for 15 years, 20 years, they know a lot. And why are you starting over every time you hire a new batch of people? Because that's what it sounds like. Like, why not have these, in your organization, these groups of people that have worked with tribes for years, that have really like learned a lot of things, and they get together and they begin to archive the information, codify the information. And then when you have new recruits, it's a part of their onboarding maybe to convene with these sages of your organization that, like maybe they get a mentor that's already been in the trenches for a long time, but too much, it sounds like to me, when I go to these events, a lot of institutional knowledge just goes out the door without it being captured by your organizations. And then that becomes the reason for, the lack of progress. So I'd like to suggest maybe just old-fashioned getting together and learning from people who've been in the organization and then finding a way to archive it and codify the information and to repeat it on a regular basis. Thank you.
Wanted to see if there was any other questions from tribal representatives, any tribal leaders, tribal representatives, or other panelists in the room. Okay, and then Amanda, if there's no more questions in the room, I think there was at least one question online. Do you want to? Okay, thanks, Amanda.
All right, we have one question online from Diane McHenry. Diane's question is, why does SDG&E and the BIA do their own environmental review when the NEPA has been approved by the grantor agency? Not sure who wants to answer that. BIA maybe? Okay. Go over there.
Could you hold that close so they can hear you?
The grantor agency is the Bureau of Indian Affairs. I think we needed a little bit more clarification to respond to that.
So, oh, sorry. I'm not sure if we can get clarification, but I think, were they asking that, why is it that that the BIA who's granting the easement, or SDG&E who would be the grant, or is able to, are they asking why somebody else isn't preparing the environmental review?
They might be. Diane's on the line. Diane, can you unmute yourself?
Can you hear me?
Yes, we can.
My question simply is, on all new homes, mostly that comes from the HUD grants. Given that, before HUD releases their funds to do any construction, you have to complete a complete NEPA review. So that's done. HUD then releases the fund. I'm sorry for the dogs barking. And SDG&E tells me they do their own environmental. Then BIA does their own environmental. Why are we doing 3 environmentals? That's my question. Why can't BIA and SDG&E give me their forms and I could take a look at them and say, this has been done, this has been done, this has been done, and give them the entire NEPA package so that they can see that all of the requirements have been completed?
I can respond to that. And thank you for that comment because it comes up quite a bit. Each federal agency, while they have to satisfy NEPA, have different documents. So you're perfectly on point there. However, when we're looking at HUD 184, not 184, just HUD in general, they have a NEPA checklist that the Bureau of Indian Affairs utilizes. However, it doesn't satisfy the NEPA requirements in total. So I understand the frustration. I can't answer why everybody can't get on the same page, but just know that if those are submitted to BIA, we do utilize those HUD checklists.
Most of the time, yeah, for NEPA that's approved by other federal agencies, we do look at them and we see if they're adequate for BIA's needs. If there's certainly a certain catalyst that could be applied. But it's case by case. There's no one size fits all. So we do have to review every single one project and look at what was the NEPA that was approved by the other agencies, and then we see if all the requirements are met from what BIA requires. So that's kind of why sometimes we could use them and sometimes we have to look into it to see if there's a way to use them.
Thank you. And Amanda, there's no more questions, no more questions online. So I think we're going to wrap up the public part of the workshop this afternoon here. I want to thank all of the participants today, the representatives, the tribal elected officials, tribal representatives, all of our panelists. I want to thank the investor and utilities, the telecommunications entities for being here today, for bringing technical experts in your teams. I am hoping that this is the continuation of a really positive dialogue where we can get resolutions to the issues that we heard from the tribal folks today, and as others have suggested, to start an ongoing discussion and collaboration on these issues. I want to thank everyone again for their participation. I want to thank Rincon for hosting us today in these beautiful facilities. I want to thank Amanda for all of the work she did in facilitating and putting the panels together and working with everyone to make this happen. I want to thank our IT folks for coming down and making this available for folks that couldn't be here today that wanted to listen in, and all of the folks on the dais, and just give them a chance if they wanted to make any comments before we close out this part, and then take a short break before we go to the government to government portion of the day. Okay, it doesn't look like there's any comments from up here. So thank you again, everyone. I really appreciate the dialogue and all of the questions and responses, and furthering the conversation. So thank you. And we'll take about a 10-minute break.